Welcome to Savage Minds. I'm your host, Julian Vigo. Today's guest is Michael J. Hopkins, a legal scholar and former practitioner working at the intersection of international law, social sciences, military security studies, and social theory. He currently works in Oxford as a senior lecturer in law, teaching international human rights law, humanitarian law, research methods in international law, and property law. He previously worked at the United Nations International Criminal Tribunal for the former Yugoslavia on the Milosevic case with the UK Refugee Council, and in private practice dealing with transnational organized crime. He is the author of The Rule of Law in Crisis and Conflict Grey Zones, published by Routledge in 2017, and the forthcoming Information Psychological Operations, Doctrine, Law, and Strategy, also to be published by Routledge later this year. His research and writing examine how law operates under conditions of conflict, political stress, and strategic ambiguity, with particular attention to transitional justice, malign interference, strategic resilience, and the regulation of influence and information operations. His recent work also addresses housing law and housing rights, monitoring, reporting, and fact-finding for serious violations of international human rights and humanitarian law, and the role of state and non-state actors in processes of social progress within international and regional institutional frameworks. I welcome Michael John Hopkins to Savage Minds. There is a major synapse within public understanding of what international law means and what it actually does. And a lot of people these weeks, especially since 3 January, have been saying, but isn't that illegal? And I tell people all the time, the U.S. has kidnapped leaders before. This isn't a new thing. Is it illegal? And what does international law say? And then, of course, what can international law do? So I was thinking if we could kick off with a kind of basic outline of the theory of international law versus its practice. The readers of Savage Minds and the listeners of the podcast, they hear about various ICC and ICJ hearings. Again, many don't understand the difference between those two bodies I've just mentioned and their relevance, while no real effects of these judgments have been demonstrated, unless, of course, you are Robert Mugabe. So I think a lot of people have begun to clue in that international law seems to only have a certain resonance for the global south leaders and countries and quote-unquote genocidal maniacs, but not for us in the global north, not for our BFFs.
That's right. And I think at the moment, when you read a lot of narratives and news stories and people in the commentariat, I think there is a lot of discussion about the end of the international rules-based order and international law. But I think for many people like us, that have kind of been born and raised from, for me, the 1980s onwards, and for other people kind of having lived through the 1950s, 1960s, 1970s. I think a lot of what we're seeing now is nothing new. There's been many international crises and kind of conflicts and crises perhaps are the kind of norm rather than the exception. So I think it's important not to take things out of this context, and also not to be too fatalistic, because what we see from the 1960s, 70s and 80s, perhaps even from 1945, we do see the kind of the enduring importance of international norms as a kind of legal idea, but also as a social and political idea, and also mechanisms. And just because something doesn't happen immediately, we do see that when ethno-nationalism, militarism runs out of steam and we've got spaces devoid of legal and moral sense, then transitional justice has a tendency to kind of re-emerge and fill that when people need to cooperate and live their ordinary lives. So just to begin with your question, then I think, yeah, you're right. It's important to start out with a theory of international law, because I think a clearer theory can understand kind of how it actually benefits our lives and endure. And also it can help us to clarify our expectations. If we've got very, very high expectations of international law, we're going to be severely disappointed. But if we see it for what it is, perhaps that is more practical, and we can kind of come to terms with what will happen now. So I think just to open, I think for me, kind of my area has been international criminal law, working in refugee law, human rights law at the international level, and then working in property law at the domestic level. And I think for me, I want to kind of go beyond my own work really and say international law is not just about war crimes and invasions, but it's an operating system for modern global life that even people like Trump have benefited from it. And most people seem to only notice it when it breaks. But behind all the narratives in the news at the moment, it's still quietly structuring trade, communication, health, and finance. So where does it come from? And then we can say, well, it comes from the kind of the age of empire in the 19th century, where kind of states govern their kind of interrelationships. So empires and states govern their interrelations through customary international law. So basically, that just means that it's not written down in a contract, it's not written down in a treaty. It's just what states do because they believe that they're required to do it, and it facilitates their relations. It could be sovereignty, diplomacy, trade, even the conduct of hostilities. So I think it's important to note that when we go from the 19th century, we go into the 20th century and we see a kind of what I see as a kind of civilizing trend, a kind of a civilizational development, really, because from kind of the Yalta Conference in 1945 and the San Francisco Conference, so Yalta in 1945, I believe it was with Stalin, Churchill, and Roosevelt. States start deliberately to build systems governing, over time trade, human rights, environmental protection, public health, aviation, telecommunication, shipping, nuclear safety, and even international criminal accountability. So we see it going from being kind of state versus state to states developing international rules, international legal and political bodies. Um, that can go against individuals. So I guess that's the Nuremberg model, kind of international courts against individual criminals. But also, I think really kind of interestingly, we see the growth of international human rights law from just a kind of a political mechanism to a legal mechanism where individuals can bring actions against states before international courts, and this is based on state consent. So just to step back, because I think it's a time of fatalism and despondency, and it's really difficult to keep track of all the fissures and fractures at the moment. So I was thinking today, what am I doing in my everyday life? So I've just bought things from Italy, I've bought things from China, I've bought things from Europe. So international law kind of standardizes international sales contracts to reduce uncertainty when we're sending goods and services across borders. If there's a dispute between international companies, then they can go to arbitration and resolve it. And domestic courts can just take these. They don't need to rehear the case. We've got global shipping rules that provide for freedom of navigation that we all benefit from and prohibits privacy. We've got global telecommunications and satellite use. So perhaps this conversation is occurring through these international agreements right now. We talked about COVID before, and I think kind of pandemics and even climate change goes beyond the ability of any one state or policy to be able to respond to. So with the international health regulations, there's a system of global disease reporting and mandatory outbreak notification that promotes resilience, I think. For me, one of the most important successes of the 1980s was the Montreal Protocol that encouraged international cooperation to protect the ozone layer. Then we've got frameworks for nuclear safety and even a global postal system. So I got a guitar amplifier today. So if you purchase a stamp in one country, it can be recognized elsewhere. So I guess, you send a package, use GPS, you drink safe water, you rely on global banking. International is there, it's there now. So people say the rules-based international order is ended. I think ordinary people who want to develop political networks, communities, trade, it's still functioning, it's still there at the moment to a certain degree. But then we could also kind of talk about certain other areas. We've got international law, it goes into different areas. So we could say we've got the framework for international peace and security, kind of set up by Churchill, Roosevelt, and Stalin. And they, after the Second World War, set up the UN Charter that kind of had international norms prohibiting the use of force unless it's in self-defense or through collective security, tries to encourage peaceful settlement of disputes. And we could always say, we tried to domesticate power and to make war unlawful, except in tightly defined cases. And then we could go into kind of international law and human dignity. So through this framework, we've had, the Universal Declaration of Human Rights, declarations on women's rights, elimination of racial discrimination, and this process of discussion, political consensus has led to legally binding treaties, but not always legally binding mechanisms. That's important to note. And it's developed kind of consensus on core ideas about human dignity, equal and inalienable rights that have come from India, have come from the global south, and they fought to have these included in the Universal Declaration of Human Rights. And the rule of law, so, separation of powers, I guess important for the United States right now with executive overreach and rule through decree, equality before law, presumption of innocence, independent impartial courts. So I think just to kind of come out of the first question, really, I think it's important to have realistic expectations, because if people think international law is about enforcement, kind of having an international police force that can go in and arrest Robert Mugabe and put him in prison, I think that's a very kind of limited and kind of unrealistic expectation of international law, because it simply does not provide for that. The UN system of human rights and many regional systems come from state consent, and perhaps all states have consented to is a range of like legally binding treaties with no legally binding enforcement mechanisms. That's the UN human rights system. And we could say these have functions that are declaratory, to set standards in declarations and treaties, are promotional. And I think we shouldn't undermine that. It becomes part of our language, our culture, education, awareness, monitoring, reporting, fact finding, so we can play the long game. And also implementation. So again, that's kind of monitoring, reporting, fact finding. So I think what we could say is kind of theory versus practice. In theory, we've got sovereign equality, fundamental principle. So you can't use force or coercion to undermine the territorial integrity of states. In theory, these universally apply. In theory, no unlawful use of force. In theory, accountability. But always, right from birth, we've had a system of veto politics, selective enforcement, strategic interpretation, and not only non-cooperation with courts and political bodies, but actively undermining them. So we could say international law is universal at a conceptual level. We've got general norms prohibiting torture, equality, dignity. We've got civil and political rights, economic, social, cultural rights. But I think always we've had a problem, not at this conceptual or global level of these general vague words, but at the level of one, interpretation. What do we mean by education? Is it primary to tertiary? What do we mean by democracy? Is it every 1 year, 5 years? Can women vote? Can children vote? So at the levels of interpretation, but then enforcement, we've always had wide divergence, and we refer to that as a margin of appreciation. States are free to do whatever they want to do, and international political or legal bodies will refrain from intervening, supervising, and judging it. So I think we've always had structural limits designed into the system. So if people say we've got an erosion of a rule-based order, I think straight from 1945, we've had limits baked into the system. The states from the start built a system in such a way to minimize any accountability and then enforcement. So we've got examples of Security Council veto. So the permanent members can block enforcement against themselves. We've got a system of kind of International Court of Justice, and its jurisdiction is based on consent. Is Russia consenting to being reviewed? No. We've got the UN human rights system. And as stated, we've got legally binding treaties, but the UN Human Rights Committee, the Committee on Elimination of Discrimination Against Women, can't communicate legally binding decisions. And in any case, this system is kind of underfunded and undermined. So we've got a system whereby individual complaint mechanisms, individuals have to go through their domestic systems first. That could take 10 years. And then they've got to go through these mechanisms that are underfunded. So even if states were cooperating with them, the system doesn't have the funding to be able to do its job properly, and the review tends to be very general. You could be dealing with housing or the rights of people with disabilities, and the review might be limited to a paragraph. It doesn't uncover the kind of the networks of power criminality. So I think saying that we're in bad times, we've got states who've created rules and legal and political bodies, and state, civil society actors and victim communities can feed into them. But I think this system doesn't collapse easily because one of my favorite authors, Karen Alter, she produces this idea of regime complexity or regime complex. We've produced a fragmented system of overlapping rules and institutions with no clear hierarchy. And this allows states to kind of do forum shopping and strategic litigation to promote their strategic ends, narratives, cover up. But I think from the point of view of victims, victim communities, civil society actors, that creates parallel accountability routes. So if they're blocked in one forum, they could try another. So for me, some kind of really interesting examples of this is kind of like Palestine and Georgia not being able to go to the International Court of Justice. So they use alternative complaint procedures before the Committee on Elimination for Racial Discrimination. They can use those because states created them and forgot about them. If the Security Council's blocked, we can go to the General Assembly, like the situation in Syria. If the ICC is blocked, then there's this notion of universal jurisdiction where it can be taken up, if possible, by domestic courts. More recently, we've got the Human Rights Council in relation to China and the treatment of the Uyghurs. So that was blocked by China, but then the kind of the Office for the High Commissioner for Human Rights could take it up. So I think this duplication is kind of bad and inefficient, but it's good. So just to take the long-term view, I think international law is always there as this free-floating community thing, and it can endure periods of limited enforcement and impunity. And during these periods, it can operate as a kind of declaratory and promotional thing with no real enforcement. But what we've seen from transitional justice is from 1945, we could say that the Nazis and the Soviets thought they were immune. In the 1970s, the Khmer Rouge thought they were immune. In the 1990s, the leaders of Yugoslavia thought they were immune, and leaders of Rwanda thought they were immune. But sometimes politicians get old, they get senile, transitional justice is there, and it can descend where where the legal and political conditions are right. And my belief, I guess it's more hope and idealism, is that counterproductive negative social forces are time limited. They tend to wear themselves out, whereas transitional justice is pretty much enduring. So that's my that's my theory of international law, if you like.
A quick question about Georgia. You said Georgia could not approach, was it the ICJ? Is this
Yeah.
linked to its case against Russia back in, I forgot the year?
Yeah, kind of going back to 2008. So I think
Yes.
basically for the International Court of Justice to work, in terms of its kind of compulsory contentious jurisdiction, then both states need to agree to it. Almost like, again, with the International Criminal Court and the crime of aggression, you need both states to have kind of ratified the kind of the ICC statute and then the kind of the Kampala Declaration that recognizes the crime of aggression. So we've got that route shut down. And the advantage of having this kind of fragmented international system is if one pathway is blocked, states not only can use it strategically, but also victims and victim groups. So let's say with Georgia, we see Georgia using interstate complaints procedures before the Committee for the Elimination of Racial Discrimination and the Convention Against Financing of Terrorism. So rather than kind of getting the particular claim that you want, you frame it up in another rule with another mechanism. And also, I guess with Georgia, we also see Georgia using the kind of the European Court of Human Rights as well to kind of address kind of human rights. So we go within the framework of the European Convention of Human Rights there, kind of the human rights violations of Russia, let's say kind of in the period like before and after the kind of the armed conflict phase. Because if we go into a situation of armed conflict, the kind of the general theory is human rights don't apply to situations of armed conflict. But because of this problem with regards to Georgia against Russia And then before that, the case of Bankovic with regards to NATO in Serbia, we've got this notion that, and we've got these periods kind of before and after an invasion phase where certain human rights obligations could apply, and that could be, the rights to life and the procedural obligation there, which is to investigate any violations, if you like. So I think that's an important development that we've seen after Bankovic. If states are using force abroad, then they should expect, what's termed aliens, so nationals from other countries, to bring actions against those states. And we see this notion from the European Court of Human Rights. We see it before the International Human Rights Committee in relation to Uruguay and Cuba. And we also see it before the American Court of Human Rights. So I think that's kind of really important. And we can talk about Venezuela, obviously, a little bit later. But outside of a conflict, when states are using force abroad, if they act abroad, they carry human rights obligations with them. So I hope that helps. So I think it's really useful to look at the European Court of Human Rights, Georgia against Russia. And
right,
also,
exactly.
Yeah, and I think it's really important because for me, I've been observing the European Court of Human Rights since at least 2008, in particular the cases in Turkey, but also um, the the cases concerning Russian activity in Grozny. Sorry, the name escapes me at the moment. But in terms of kind of Russia in Grozny, we've got cases such as Isaeva against Russia. Could you just remind me of? Sorry, I've just had a mental blank. So we've got Grozny, and that's in the region in Russia of Chechnya. Yeah. So in relation to Chechnya, I think we've had Russia. People say kind of Russia with its, it was 2014. We could go all the way back to kind of 1998 with with Chechnya and what Russia was doing there. And we did try and call it out and kind of warn Western leaders, but human rights mechanisms were observing kind of the actions of Russian military forces in Chechnya since 1998. But the politicians, they chose to carry on, kind of doing business with Russia essentially. So, this is nothing new if we look at the records, but in particular the legal records.
I mentioned Mugabe because it seems that every time international law is discussed in legacy media, but with this fervor of now he's going to be in trouble or now she's going to get it, it invariably has to do with non-Western nations. So in the run-up to the kidnapping of Maduro and Flores, of course, many people had no clue that this has been executed before by the United States. We can go back to Noriega, but there have been so many instances of the United States breaking international law and having no reckoning for it. You mentioned veto powers within various institutions. As we all know, the U.S. has vetoed many measures that attempt to censor or discipline or speak out against Israel formally within the United Nations. I forgot the latest count, but just most of the U.S.'s veto powers have been to protect its BFF in the Middle East. So obviously, this leads many people who are learning about these procedures, these institutions, to doubt their efficacy or even the good faith that we allegedly put into them, each and every state. Because what's the point? If at the end of the day, Trump can order the kidnapping of a president and his wife, threaten to invade not only Cuba, but Mexico if they dare send petrol Cuba's way, etc., etc. But we've been here. We can go back to the global war on terror. You mentioned the laws that mandate certain kind of health measures, public health measures. There have been a lot of people pushing back on this attempt to sort of create a tabula rasa over domestic laws in every nation should there be another pandemic. There were talks the last few years to have the WHO have this kind of overarching power to lock down countries irrespective of those national laws or those national assemblies, parliaments, senates, etc. So this makes many people nervous because I'm in a country that suffered greatly during lockdown, Italy. Our lockdowns were crazy. We had to print out papers to leave the house to go to food shop. Print out papers and say what we were getting. We were stopped. I was stopped I was the one in my family that did the shopping. I was stopped more times than I wasn't. As a new immigrant to Italy, I was very nervous. And then I began to wonder, wait a sec. Why is it that we don't have the right? Like by week 8, we saw what the demographics were. It was clearly the same as for the winter flu. People began to question, I certainly did. And I thought, wait a sec, prisoners in prisons are being held. They might have more rights to exercise than do we here in Italy. How is this right? Why have there been no international bodies speaking out about this very draconian measure? I ask you this because, this is something that's gravely affected our lives in Italy. They've had loads of mental ill health in this country since lockdown. The government will not speak openly about it, but they do by means of, we have a psychological bonus we're offering people, and they've had to remandate it almost every year since lockdown because of what's going on. You see it. You see people who have just lost their minds. You hear people in the pharmacy saying, I'm picking up my mom's medicine, she still won't leave the house. There are elderly people who are so psychologically, they're petrified of leaving the house. What is it about international law that on the one hand can go after a Mugabe, but then we have a lot of evidence to show that Dr. Fauci has his hands dirty regarding the way this virus began? And obviously, we're not going to go and invade Maryland, where it is very much believed by many people who've investigated this story that the virus began, or was it Wuhan? But so what do we do as citizens of the world who don't want ethnic cleansing in these countries, or who watch the Gacaca courts form after the 1994 Rwanda genocide, where people were at least brought to some semblance of justice because of the Gacaca courts, as you know, were instituted because they didn't have the human power to process all the rape cases that were before them. I'm just wondering, when people who, let's say here in Italy, have suffered from lockdown or from vaccine injuries, there's lots there, how can people have justice if at the end of the day we're given this vision that international law pertains to Milosevic or Mugabe only, and not to the people who locked us up for the better part of 2 years in this country?
So let me start with a few initial thoughts then on that. Start very broadly and then zoom in to some expectations. So I think, what is international law? Well, it's words on paper. It's a series of concepts. But more than that, it's concepts that we share globally. And before the, as you stated earlier, before 1945, and then all of the civilizing rules and mechanisms that we had coming out of that, we didn't have this shared language. Also, we didn't have global institutions for monitoring, reporting, fact-finding, so we could discover what's going on in Italy, what's going on in Zimbabwe, what's going on in Nigeria. And from my experience working with the ICTY, working with the Refugee Council, it's brilliant having this global observatory so we can discover both at a kind of systemic level, but also kind of down to kind of what's going on in people's minds, people's motives, people's networks, how kind of we go beyond the geopolitical strategy to the individuals, to their motivations. And we've got a shared system of like language, organizations for kind of uncovering that and exposing that. Once we've done that, then the second question is, well, what do we do about it? And there's so many levers of state power, which may not act in the interest of individuals, but so many levers of kind of international civil society that's really, civil society actors, NGOs, domestic human rights commissions, victim communities can really, they've got standing to try and kind of tell their stories, expose what's happening. So the one thing is kind of, we could say, perception of the environment and what's happening. Then we can understand the kind of the harm that it's causing and who's responsible for that. But then the last question is kind of responses, and we've got diplomacy, politics, media, military, economic lines of operation. So I think fundamentally, you're the wrong person to ask because I'm a lawyer, and usually our frame of reference is we get activated when it's managed to somehow get to court, and you've got a state there, or another state, or an individual in a state, and then we apply a very kind of select set of kind of rules. Um, the facts we review is like very selective. But as I get older, and I think it's a privilege working with savage minds in particular, because I just think I want to be part of a broader kind of community with journalists, anthropologists, poets, and things like that. Because I think at that kind of like ground level, as kind of Gramsci would, at that ground level, people with their ear to the ground and being able to kind of understand the environment and respond to it. And I think really it's kind of it's at the community level, and we could say that's kind of national, but it's also regional and international now. Kind of, I think people getting that connection with the political economy and kind of trying to draw the line to um, kind of stop the political economy behind all of this. And then law can come after to kind of get it on the record and adjudicate it. But from my memory of the 1970s, with like crimes happening in Chile with Augusto Pinochet, and I just remember the kind of the people of that age of that era kind of blockading ports to stop weapons being put onto boats, and with South Africa, people withdrawing their funds from Barclays Bank because they didn't want a bank investing in a they didn't want a bank investing in an apartheid regime. And I think it's making that connection. Kind of international law is just one kind of line of operation. It's a legal line of operation amongst others, and all should be applied, but sometimes we need to kind of like sequence them over time. So I think, we just have to be realistic. And what you say about your viewers and people, I think, is entirely right. Almost every powerful state has violated international law at some point in time, and the question is not just whether violations occur, but whether accountability follows. And you've noted Russia. We could kind of talk about US and Iraq. And one of my favorite papers was written by Joy Gordon. It's this paper called, Perfect Injustice, looking at the US sanctions regime in Iraq and how that led to kind of a really high infant mortality rate, and how it was just kind of open knowledge at the time. We could talk about China and non-compliance with kind of international law in the South China Sea, Israel. But one thing that really kind of startles me is the European Court of Human Rights. At the moment, we're starting to get through the system all of the cases concerning the US war on terror, and in particular, the use of black sites, not just in kind of Iraq and Afghanistan, but within Poland, within Latvia, within Italy. And these states kind of being brought to justice for kind of facilitating a kind of an international operation of basically kind of rendering people, so kidnapping and torturing people. So we've got ICE. Is ICE something new? Well, for me, for the past 30 years, now coming before, we've got cases like Al-Masri before the European Court of Human Rights. If you want to look, there's a fact sheet on the European Court of Human Rights website called Secret Detention Sites. But we've got reckoning with ICE now, but we've got reckoning for the past 30 years that perhaps could involve George Bush and Obama for this hideous program of kind of kidnapping and torturing people within Europe itself, really. But the important thing is we've got a record, and compensation, recognition is being given. But why do states fail? I think, well, we've got structural weaknesses. We don't have, at a community level, we don't have a global police force to protect us as communities. And perhaps in the United States we've got community groups activating now to try and protect themselves. We had that, I guess, also in kind of Northern Ireland as well when we had occupation there. Enforcement is through the UN Security Council. Are the wrongdoers going to kind of check themselves? We've got veto powers, and we've also got political trade-offs, so very kind of short-term thinking, if you like. So what I could say is kind of international law doesn't necessarily provide an incentive structure. I guess for me, kind of human rights promotes legitimacy, good governance, resilience. If you've got a good healthcare system, if you've got good monitoring, accountability, then if you have a global pandemic, then you've got systems in place, so a state does not need to go into immediate crisis mode and take these very repressive measures, really, because you prepare, you think in times of peace. So you go down a pathway which is like, we're ready for this. I think in terms of human rights law, I think kind of where you've got norms or obligations, then it's useful to have a clear incentive structure. And I think there's just this kind of notion that human rights doesn't have an incentive structure, but for me, it promotes legitimacy, good governance, and resilience, and that helps states and communities prepare for crises without states having to kind of respond through kind of very, very kind of quick thinking, repressive measures. And today, I think in the news there was discussion about Donald Trump pulling kind of climate change legislation to make kind of cars kind of cheaper. But then I think all that does is it just kind of it this short-term thinking, these kind of political trade-offs will just kind of create future costs. They're actually far more expensive for the powerful figures themselves and individuals, really. I mean, one thing that I would just like to kind of, discuss and draw attention to is the other last week, I looked at the UK government and it released a national security assessment called Global Biodiversity Lost, Ecosystem Collapse and National Security. So perhaps we can worry about repressive states, but all these repressive states have a far greater challenge ahead, which is the planet dying. And from this report, the conclusions that the UK government draws is that there's a very, very high probability of global ecosystem collapse, which threatens not only national security and prosperity, but intensifies crop failures, natural disasters, and disease outbreaks. And it's just startling that perhaps what we thought might happen in 2050 or 2060 is happening now. And we might not have water, we might not have food. So I think one of the important things about human rights is it gives us the norms. It gives us the organizational structures to start thinking now, and that's in everyone's interest, states themselves. So I think we just need to kind of say there are political incentives to adhere to norms because they promote good governance, resilience, and to try and kind of get the discussion going now that this is important to frame kind of national security issues, more kind of like long-term thinking. So when we have ecosystem degradation and we've got crop failures, disease outbreaks, we're kind of ready, we're primed, ready to go. But other than that, I just think we've always had strategic behavior, and it's important to start thinking about it now so states don't do it in a very kind of short term, narrow, repressive way. I mean, this is something that I've always seen when I was working at the United Nations. There was some discussion about not only investigating Slobodan Milosevic, the KLA leaders, but also investigating NATO for kind of like bombing radio and TV stations in Serbia. And when there was talk about having an investigation, about having a formal investigation, the United States immediately withdrew millions of dollars worth of funding for the ICTY, you know. And at the same time, we had George Bush put into place something called the Hague Invasion Act, which is like if you indict any of our service people and capture them and put them in a detention center in The Hague, we will invade you and recover them. So this is nothing new, but I think one of the issues we have, and we see with the ICC now with like travel bans and asset freezes, which I think is just basically perverting the course of justice. We've got this notion of normative erosion, and we look back to the Armenian genocide. Nothing was done then. What happened during the Second World War? The Second World War, kind of led to many of the issues that we're having now. So I think it's really important just to use law as a compass. There's times when it just doesn't apply, but then when we've got societies or communities emptied out of legal and moral norms, like ordinary people who want to live ordinary lives in peace will need to refill it. And one of the feelings I have is within this kind of complex international framework, I strongly believe that because it's so fragmented, because it's so horizontal, it's beyond the ability of any one dictator to switch it off. They can try and they can try and shut down one mechanism like the World Health Organization, or a domestic aid agency, but there's other mechanisms that can kind of step in, and perhaps we're seeing civil society actors, international community now kind of responding to that. As soon as United States does something, then we could see, you've got hedging both with civil society actors, but also states themselves. But for me, I feel like it's nothing new. I think what was kind of really important from my point of view is 1945 with Nuremberg.
Yeah, I was just thinking of it as you said it. I was actually envisioning Nuremberg because isn't that the kind of beacon that we follow ethically?
I think it is, yes. So I think, like, if I draw a parallel now between the Nazi regime and many forms of authoritarian legalism that we see now, and I won't single out any because I think it's important just to stay on kind of general terms, but you do see some kind of unitary executive ruling through decree, if you like, and saying we create norms, we create our own rules that justify killing people who cross borders, killing people in foreign territory. That's kind of nothing new, if you like. But I think Nuremberg is important because it takes customs from the 19th century and put them in a codified treaty. And we could, war crimes and, crimes against the peace, but also started to talk about crimes against humanity. That's important to discuss later. Puts that on a formal, kind of textual statutory basis, and that can lead to other mechanisms. So these people thought that, international customary norms and didn't apply to them, but there came a point when their their projects, their Reich, their empire building project fizzled out because of its own contradictions. And then, like a cloud, this could descend. And there was this notion, I guess, with Churchill, Stalin, and Roosevelt, that part of our war aims of defeating these these tyrannical regimes is through the law. So we can prove that we're not worse than them, we will subject them to the law. And Nuremberg, I think, was just from a legal but from a historical point of view, this forensic account of crimes of the state, systemic criminality for anthropologists, historians, criminal lawyers, that forensic account of structures of power, how bureaucracies can be used, how finance can be used, how ideology connects with bank accounts, connects with a system of repression and extermination. It brings it all out into the open and enables us to do something about it. But Nuremberg is important because I think straight after Nuremberg, basically, it was put into the freezer. This project, crimes not committed by states, but by individuals, and we can hold them accountable. This notion of universal jurisdiction, wherever it happens, there's a mandatory obligation to prosecute or extradite before national courts or hand over to international courts. Put in the freezer, nothing for about 50 years. And then in the 1990s, we see the International Criminal Tribunal for Yugoslavia and Rwanda bringing Nuremberg out of the freezer and developing it, taking all these norms, developing notion of war crimes, kind of what is international armed conflict? What rules apply to non-international armed conflict? Developing kind of crimes relating to sexual and gender-based violence, really kind of fleshing out what these means and having a system where it's not just this general abstraction, the state, but we can figure out the individuals behind that. So we've had like ICTY, ICTR in the 1990s. We had the International Criminal Court. But if I'll be honest with you, I feel that this project is, as as you suggest, it's been put into the freezer and sidelined. And the ICC perhaps is kind of focusing on various African countries, but then power politics, realpolitik never goes away. You've got United States, not party to it. And again, that's the issue. International law, it's based on consent. So if a state hasn't ratified the ICC statute, then it simply doesn't apply. But we do have customary law. These rules can say, look, they become customary, and we do have the Geneva Conventions from 1949 that have this notion of kind of grave breaches. So let's say when you look at Ukraine at the moment, and there's this kind of this formal arguments that, okay, well, crimes against humanity um, don't apply before 2022 because these weren't formally integrated into Ukrainian domestic law by the government. Well, you could just say, actually, no, it's these are kind of customary laws, so we can kind of get you that way. And that's the exact same argument that we saw with the ICTY. Kind of people said this treaty doesn't formally apply, and an international court would say, well, actually, we can use customary law as well. That's a source of law, so we can get you. So I think I agree with what you say, and I agree with kind of what you say about what your kind of listeners. I think that's correct kind of perception, and it's realistic, and it's important. It's important to kind of say, well, actually, yeah, that this is a realistic assessment of what's being created and how that's being achieved. And at the moment, we're in a time of political pushback where kind of universal jurisdiction, individual criminal responsibility is being put back into the freezer. So we tend to oscillate, but I think the system still matters. I think at the moment we can use this share language to kind of declare norms and have expectations about these norms. We can hold states to these standards in the media, in political forums. We can promote it. And at the moment, we're monitoring, reporting, fact finding. We can only hope for some occasional enforcement, but at the moment, we've got media discourse, civil society campaigns, domestic litigation, sanctions regimes. Kind of maybe someone can't go after Russia or United States or Israel, but then if you've got an international court judgment or a political declaration, then there's pressure at the kind of national level to say, well, if if you've got a domestic regime for kind of licensing exports, you can't export certain things to these countries, Russia, Israel. So we don't tend to think about these kind of indirect things. Oh, it doesn't apply to Israel. Well, actually, if you've got this international judgment, then there's pressure on the German state not to send component parts to a Russian proxy, so Russia can get its hands on it, etc. So I think what we could say is international law not designed to eliminate power, designed to civilize it. And it's a compass that we can use to fill spaces devoid of legal and moral sense. But from a human rights law, I have to say, I think you're right. We've got human rights like, you talked about lockdown and restrictions on movement. So from a European perspective, Article 11, freedom of association, these have been constructed and accepted as qualified rights, which means that it applies, but then states can legitimately interfere with these rights if there's a legitimate aim, and legitimate aims could be something like the protection of public order and public health. So if you've got a public health emergency and states resort to these very repressive measures, then sometimes human rights mechanisms will say, actually, again, that notion of margin of appreciation, this interference is justified. So states have created within human rights treaties all of these get out clauses. And we could say to a certain degree that is legitimate. If there's a national security threat, let's say in kind of like Northern Ireland, the state needs to protect people from, organized criminals who have got political, economic motives. It's protect people from pandemics. But within that human rights regime, there's the sense that we will monitor it and supervise it to keep it under review. So when the threat's gone, we will put pressure on you to return to the rule of law, if you like. So we could say that human rights, kind of politically, but also legally, is a kind of conversation between state to state, but also kind of international mechanisms to states to try and keep everyone in line. And I'm sorry to kind of lower the tone of the discussion now, but I think it could be like, when you're a young person and you go out drinking with your friends and someone imbibes too much and gets inebriated, and then friends will kind of look after each other. And when I look at the early discussions from the Council of Europe and also the international system, when you look at these diplomatic conferences, there's always this talk about international law as a political but also a legal thing is important, as Churchill said, to prevent what Montesquieu described as the reasons of state, which I guess is this constant tendency, even for democracies, to backslide. We can monitor each other and try and keep our standards up and kind of keep our vision high, if you like. But I think we can't have too many expectations of law. I think as a lawyer, I think it's very ineffective and it's got a very limited mandate and purview. For me, I think one of the most important things is that connection between civil society and communities on the ground and political economy to kind of pull that lever. But at the same time, I think it really is important that we all have that connection to a kind of global language and global systems to give what we're doing commonality, legitimate aim, purpose, if you like, and legitimacy at the same time. Because I think when we've got legitimacy, that means that this project that we've got going on, and it's an ongoing project, has that enduring, durable quality. Just one final case, if you like, the case of Strelets against Germany. And in that case, you had former members of the German Democratic Republic who were prosecuted before the German courts for um, for killing civilians trying to cross a border. And they were convicted for this, but then these former political military leaders, they themselves then went to human rights mechanisms to say that convicting them violated their human rights. Can you imagine it? Violators claiming that their human rights had been violated. And the European Court of Human Rights just said, well, actually, you created your own national system where you created laws to justify this. But at the same time, at the international level, even within your own system, like you signed these international conventions to show that, the kind of the Soviet system, communism was a progressive thing. We're going to hold you to your own propaganda now. And we're going to say that there was a legal basis for convicting you. So when I look at cases like Strelets, that kind of gives me hope because you had people committing crimes in the 1970s, and it took until the kind of the 1990s and even now and going to the 2010s, it took it 70, 80, 90, it took 30 or 40 years for justice to catch up. And in some cases we do have it. So I guess we can only hope that the kind of the leadership in certain countries who are getting old and senile, that I guess kind of leaders and political systems, I guess you could project onto them psychologically. They do get old and senile, and I think at some point they might want kind of compromise and consensus. Um, at some point they want stability because they can't go on fighting. At some point they get weak, and other powers or the international community can then say, well, actually, we're going to get everything out of the freezer now, and we're going to apply it. And that could be for various functions. One is education, I guess human rights, international criminal law. We could say it's got a didactic function to educate people about what happened and why. We could say that feeds into deterrence. But yesterday I looked at a report called War Watch from the Geneva Academy, and they're just saying because of the past 30 years of non-compliance, that's just led to a situation of complete impunity, and they looked at 23 to 25 with hundreds of thousands of civilians being killed. And at some point, the world needs to be reckoning with that. When that time comes, we've got people in politics and law with the concepts, the training. That includes journalists, but it also includes lawyers, how to carry out investigations of atrocity crimes. We've got knowledge and we've got a skill set. And it's just a question of one of my favorite jurists was called Antonio Cassese. brilliant Italian jurist who is the president of the ICTY, International Criminal Tribunal for Yugoslavia, set up the UN Committee Against Torture with kind of on-site inspections. And he once said something in a lecture that's always stayed with me. He said in 1945, we created the blueprint for a new international system that could promote international community, kind of international standards. But we have chosen never to fully live within this system.
This is the sign of the times as well. When you said Nuremberg, my brain was right there because I think since 7 October, a lot of people have just been unable to contain themselves over, for some, the irony. And I don't think there's anything ironic. I think it's naivete if one thinks that oppressed people cannot also oppress. Of course, this is what in Pedagogy of the Oppressed, Paulo Freire warns about, actually. So it's not that because you or your ancestors were once oppressed, that exonerates you from future oppression. That's ridiculous. Yet, I think we're stuck there in a mediatic form, if you know what I mean. Legacy media has followed this. I mentioned the Gacaca courts because I remain very impressed by Rwanda's ability to handle, as best as it could, the overwhelming abuses that happened there. Over 2 million cases with a conviction rate of just over 86%. Over atrocities, mind you, that many countries in the West contributed to. And I think of something that having small children, and I'm having to explain to them, they see what I work on. Mommy, why? And then I have to say, well, why can't they just stop bringing the weapons there? This is the case of Rwanda, because the major arms manufacturer for Rwanda was France and Egypt. South Africa, Zaire, and China, they all facilitated as well. They're not going to be hauled in front of the court, or the countries you just mentioned, Germany, parts from the UK, hence the prescription of Palestine Action. One of our writers has a court date next month over this. She was the first arrested. It was the same day that this was brought into effect that she protested, and she was the only one not part of Palestine Action. Yet she held the sign saying that genocide is wrong and that she supports Palestine Action. I mention all of this together because I have a really hard time explaining to my children how, to quote Boy George, war is stupid and people are stupid on the one hand, okay? And on the other, that we have a capitalistic structure that goes unpunished.
That's
Should
right,
not France have been brought towards the courts as well? China, Zaire, all these countries that ship weapons. As a side note, is there a movement on the planet, because I will sign up to join, that bars any kind of parts or full arms exportations?
Yeah.
I think the last few years with Gaza it's hit my ras de bol button. I can't anymore. I accidentally see things on social media that leave me reeling for days. And then we go back to the lovely Madeleine Albright famous quote, but I think it was worth it, referring to the U.S. sanctions against Iraq that led to over 50,000 deaths of infants, okay?
Yeah.
And then my own work with your colleagues in the Americas. One of my books deals with what was called special registration, a special title. It was really a euphemism for what was the National Security Entry-Exit Registration System, a system, by the way, that was authorized by George W. Bush, but was allowed because of legislation back to Clinton. And this is where the disappearance of 14,000 Muslim men primarily began. So when people are upset about ICE, I'm like, where the hell have you been for the past 23 years? ICE disappeared 14,000 men. I have dealt with them. I dealt with lawyers from the ACLU, and they were explaining to me how their offices were not only full of people, but the stairwells down 20 flights all the way around the tip of Manhattan. That's how many people were there every day for months after 9/11. Where's my brother? Where's my husband? Where's my uncle? Where's my father? The Council on American Islamic Relations, can't even begin to tell you what happened there. That was wild, my work with these people, wonderful people. These people had to play a very double role in what they were doing. Early on in my work with them, it was very clear that they thought something stunk about the whole 9/11 story. And at one point, while interviewing one lawyer who asked me to turn off my recording device, which I did, he closed the door and said, "Don't you find it odd that they found Mohammed Atta's passport perfectly intact?" Well, of course, right? A plane that explodes into smithereens hitting the World Trade Center, whichever of the two towers he was in. No. This all came to a head, and it was like whack-a-mole between the crazy stories coming out, the fake investigation, because the investigation over 9/11 was clearly insufficient. We're seeing that in recent months. The American journalist Tucker Carlson has been doing an excellent series on this, but there's many others as well. And then you've got what's happened since. I really have problems to speak coherently about this because I'm very emotional when I think about my research in New York City. I was a professor in Montreal at the time. I'd be coming down to New York every other week. And it was amazing to see how the fear that was engendered by the Bush regime post 9/11 actually captured a lot of Democrats. So you had this amazing support by people who I heretofore thought were on the left, friends included, and I found myself living in this dual reality and wondering if I was the crazy one in the room, because they didn't care about the black sites, and they didn't care about Guantanamo. We're talking about Democratic voters here. And I kept thinking, what planet are you on here? This is dangerous. This goes against everything this country was founded upon. If you can bifurcate the founding and the good measures from, obviously, the mass slaughter of indigenous and slavery, which to a degree you end up having to do to describe the Constitution on the one hand. But I tell you, I am floored by the fact that the United States disappeared so many people under the auspices of Homeland Security, when that was, again, it was a renaming of the Immigration Naturalization Services, and then ICE to enforce what wasn't being done. And it's like Rwanda's done better than the United States does. Or if you remember back to the dirty war in Argentina and their Nunca Más Commission, right? And they came out with an excellent and coherent analysis of the dirty war that the U.S. has not even approximated, not from Iran-Contra, not to now, right? So I remain just completely frustrated on the one hand, because I want international law to, obviously, there is no boots on the ground without international law becoming itself a colonial power, but I would like for there to be some kind of reckoning. I really appreciate your attitude, because I have to remind people, it's not Trump. It's not Trump. Things were going downhill for a long time, folks. This is not Trump only. This is about a system that sees itself as untouchable. Goodness knows if any country came into D.C., something a lot of Democrats would like, came and kidnapped Trump and took him, that would be a call for war. The U.S. would probably launch a nuclear weapon or something.
That's right.
This is insanity. Yet we go to the deaths caused by Iraq. I've covered a few of those. Let's look at the deaths from Venezuela, 40,000 plus deaths. This is a conservative estimate for the period from 2017 and 8 because of shortages of insulin, dialysis equipment, cancer treatment, and drugs. Over 100,000 deaths in Venezuela, in addition to this, because of problems that have cumulatively added up to the crippling of the healthcare system because of these sanctions. Iran, 13,000 plus deaths attributed to inadequate medical care, especially during the COVID-19 pandemic, and also linked to conditions such as COPD, thalassemia, and hypertension. Syria, following the 2023 earthquake, but really Syria has been under-analyzed in media. It's one of the biggest human rights issues, mass migration issues of the past 100 years. Nobody talks about this. And then Cuba, which has been under constant sanction from the U.S. for decades. And the amazing thing is that when I was working in Haiti, I was working with the UN. My last book deals with this. The doctors that came to Haiti to help out were primarily Cuban. They have an amazing healthcare system, but despite all the work they've done to develop their country in the face of sanctions and now rising sanctions, they've had problems of infant mortality because of certain kinds of medicines that they cannot access. So at what point, given that recently John Mearsheimer and Jeffrey Sachs have talked about this kind of hybrid warfare, where on the one hand we can bomb Tehran and call it a day, or we can starve people to death and sicken them to death through these sanctions. What say international law to this?
Yeah, so just to kind of pull just to respond to a few things you said there, and then come into the kind of the issue of hybrid warfare and sanctions, if that's okay. So yeah, I think just starting with your point on Nuremberg, and somehow it's kind of captured your imagination. And I think, yeah, I think that that was a kind of historic moment, if you like, the point at which we can look beyond the state to the kind of the individuals and the kind of the state as a kind of system of organized criminality that involves kind of military leaders, political leaders, but also corporate leaders. And one of the things, I really want to look into more because, Francesca Albanese recently kind of wrote a report about kind of corporations and their complicity in claims of genocide in Gaza and occupied Palestinian territory. And she forensically breaks down all of the corporations, kind of construction, software involved in this kind of this system of repression, but also basically extermination. And I think that accounting is really important. And when I read that report, it took me back to, if someone thinks it's controversial, it reminded me of something called the IG Farben trials from Nuremberg. So after the kind of the key ministers of the Nazi government had been prosecuted and sent to prison or hung, then after that it started to look kind of lower down the chain of command, in particular looking at senior officials in German companies, in particular the German chemical company IG Farben, who produced the Cyclone B gas that was used for mass murder of Jews in gas chambers. And a number of the senior officials were prosecuted for basically supplying these chemicals with knowledge of its particular use. So we go from the kind of the state to the kind of the senior leaders, and then we go to the kind of the core kind of capitalist corporate infrastructure that was basically kind of facilitating this with clear knowledge of what was happening. So that kind of indicates perhaps the structure of international criminal justice and what we can expect in terms of we have these kind of these core international courts or tribunals, and their primary focus tends to be on senior military and political leaders for kind of so-called atrocity crimes. And then as we start to go down the kind of the criminal network that has committed these atrocity crimes, then that will go to subsidiary mechanisms. So from Nuremberg to control council proceedings, and then people lower down will be usually kind of prosecuted at the national level before national courts. And when we look at cases like Eichmann, then we have courts kind of like grabbing people and prosecuting them. So even Israel has kind of used universal jurisdiction for the crimes committed by the German regime. I quite like what you said about this kind of strategic use as well. You mentioned 9/11, and suddenly evidence becomes available when it's convenient. And when I was working at the ICTY, we would often see that we had International Criminal Tribunal prosecuting senior military and political leaders from like Serbia, Kosovo, Bosnia, and Croatia. And when these people were being prosecuted, and the ICTY said, look, Serbia, Croatia, you've got to supply us with evidence, because if you don't cooperate with us, that's going to affect your kind of accession talks to the European Union. So cooperate with us. There were these kind of there are these economic levers that are kind of connected with your cooperation. When there were requests for assistance, they would say things like, oh no, the government ministry that had this evidence was bombed by NATO. But then when these very same guys were kind of had their defense case about why they didn't know about war crimes or crimes against humanity or genocide, suddenly evidence would appear and they'll be like, oh, well, this part of the government ministry didn't get bombed or whatever. So sometimes there's that notion that justice seizes what justice sees, and the more mechanisms we have, the better. And like you said, one of the problems with United States of America, is not party to the American Convention on Human Rights. So you mentioned all of the dirty wars, proxy wars in Latin America, kind of Honduras, Nicaragua. The American Court on Human Rights has not been able to directly engage United States in these dirty proxy wars with mass campaigns of enforced disappearance. Chile, Nicaragua, Honduras. Like, the court hasn't been able to go against United States because United States isn't subject to its jurisdiction. So it's focused its analysis, the American Court of Human Rights focused its analysis on Latin American states. But this history of American involvement with training, funding, financing paramilitary groups engaged in, I don't know, Noam Chomsky describes it as fascist regimes, like, Pinochet, a fascist regime, supporting the Contras, undermining democratic systems through, we could say, it's international armed conflict, but through these proxy wars, it's concealed as like law enforcement, counter-terrorism, counter-narcotics. So it says, well, it's slightly below the threshold of armed conflict, so that this universal jurisdiction accountability regime doesn't apply, because it applies to armed conflict. You say this hybrid warfare argument, this is law enforcement, this is kind of secret or semi-secret training, financing, supplying weapons and stuff. Nicaragua was a good example. It doesn't. The American Court of Human Rights hasn't had jurisdiction. But the interesting thing in that case is, even though the American Court of Human Rights didn't have jurisdiction, I think it's really interesting to look at the Inter-American Commission on Human Rights and the work it's done on dirty wars, but also its kind of investigations into the US war on terror and the treatment, as you noted, the kind of the special registration, the disappearance, holding people without charge, without trial in Guantanamo Bay, and the Inter-American Commission on Human Rights. You know what I said about that kind of that fragmented system where things are created and then certain mechanisms forgotten about. These things can come back. So the work of the Inter-American Commission on Human Rights in Guantanamo Bay just said, well, look, you're not party to the convention. Okay, we've got the American Declaration on the Rights of Duties of Man. We've got the UN Convention Against Torture. We're going to hold you to that. We've got a reasonable suspicion that torture is taking place, and we're not able to get access. We're not able to legally review it. Either these people are prisoners of war, in which case we've got the law of armed conflict, and you release them when the conflict has ended, and we can kind of supervise their detention. Or if it's not an armed conflict, then they need to be subjected to criminal trials on the basis of, criminal rules and rules of evidence and procedure. US involvement in Latin America, and it's been picked up by the Inter-American Commission on Human Rights in relation to Cuba and Guantanamo Bay. It's been picked up by the International Court of Justice in relation to Nicaragua. So kind of training, financing, supporting paramilitaries to destabilize and overthrow democratic governments. It's also come up indirectly through a case that I really like, which is Velasquez Honduras against Velasquez against Honduras, which kind of looked at the Honduran government and its kind of state practice of disappearances and kind of breaking down how that was done. And it was all part of kind of trying to transition back to a form of democratic governance. And the US involvement in that was kind of sidelined because of the kind of the jurisdictional limitations. So if we look at kind of, Nicaragua situation, then yeah, I think it's kind of interesting to kind of frame that within the context of kind of like hybrid warfare and this kind of notion of kind of economic statecraft and hybrid warfare. We don't have, a clear invasion that can activate, violations of the use of force and universal jurisdiction. So we've got this notion that rather than hard force, we're using soft force, and we try and coerce state without invading it through financial strangulation, trade controls, kind of blockades, but also kind of like um, proxy wars as well. So hybrid or grey zone strategies, you tend to use kind of economic, informational, diplomatic, and sometimes proxy tools to achieve kind of, geostrategic goals below the threshold that what could trigger kind of international accountability in the future. We simply haven't violated international humanitarian law because this is below the radar. So I think that's kind of one of the important things to kind of look at that. And the kind of theorists I've read of kind of hybrid warfare tend to be people like Hoffman and Monaghan, who talk about hybrid warfare as using kind of non-violent means to achieve grand strategies. And I'm very kind of cynical about that because I think sometimes if you've got, like Rwanda, you have information campaigns that whip up polarization and hatred that results in mass violence. For me, if you're kind of inciting people, that's not non-violent. That is extremely violent. If you're within civil society, kind of activating, um, political psychologist Karen Stennis is kind of activating predispositions towards authoritarianism by making demands on the state that it be repressive or resorting to violence. So when we look at, I don't know, proxy warfare or sanctions, I think Nicaragua is clear. Like Nicaragua says, well, if you support proxy forces to undermine a state, that is a violation of the use of force. Someone might try and say it's political warfare, but basically, the International Court of Justice in Nicaragua said supporting the Contras was a violation of the prohibition on the use of force, using these means for political objectives. Elsewhere, that might be described as terrorism, isn't it? But if we look at kind of sanctions against Venezuela, I think it's important to tease that out because we reach the limits of hello. Yeah, yeah, we reach the kind of limits of international law. So if we've got the legality of sanctions, we could say, well, sanctions alone are not per se illegal. So unilateral sanctions are not automatically unlawful under international law. But we've got hard questions about how to categorize them. Do they fall within kind of legitimate kind of economic disputes, or are they unlawful countermeasures? When does economic coercion become aimed at dismantling a state and undermining its sovereignty or territorial integrity? And when we look at Iraq, but also Venezuela, when do sanctions amount to foreseeable mass harm against civilians? So, kind of as a question of fact, but also a question of law, it's kind of very difficult to kind of try and understand what's happening in practice, but also in law. So I think sanctions, when we look at, blockade or quarantine, sanctions are usually framed as kind of non-forcible. Blockades are different, and usually blockades are classically treated automatically as a use of force and potentially a kind of the crime of aggression if that applies. But a blockade is not normal economic statecraft. It's force politics at sea. I think the crimes against humanity claim, I think in international law, we've got a number of kind of interesting points. And I think kind of sanctions and constituting crimes against humanity is one of them. So just to kind of pick that apart, it's an important but controversial claim. But that's the way law develops. It starts out with this idea and then it gets traction over time. Crimes against humanity, genocide, at one point, they were extremely controversial concepts. No more. But I think at one point we've got the kind of Venezuela's domestic law, the Bolivar law narrative. And as a question of domestic law, they kind of said, well, kind of opposition forces kind of having support for sanctions that could kind of represent a kind of crime against humanity in kind of like domestic political and legal terms. So as a kind of as a domestic issue, I think it was being treated as a domestic political weapon, like criminalizing support for sanctions and used against the opposition. When we go up to the international level, we've got United Nations experts, the Office for the High Commissioner of Human Rights, kind of also kind of condemning US actions, kind of the sanctions regime, the unilateral sanctions regime, as aggression, maybe like politically, as opposed to before the ICC kind of conception of aggression. So saying that's aggression and calling on states to act. So we've got UN experts saying that economic sanctions against Venezuela are a charter problem. It could be kind of by, use of force, principle of non-intervention, and also they're creating a human rights emergency. But this is at the political level. They're not court judgments, but law comes out of politics at the domestic level. Bolivar law, and at the kind of international political level, Office for High Commissioner of Human Rights, and the authoritative interventions that open up kind of further political and legal pathways later. And it's gone into a legal pathway now because the international legal community is now kind of saying, well, sanctions, do they represent a crime against humanity? And lawyers get very particular about this. And lawyers will say, well, actually, a crime against humanity is not a political thing because we feel it, but what we need is a widespread or systematic attack directed against the civilian population. So we need that kind of directed against the civilian population says, well, the harm to starve a civilian population has to be the primary object. So if the United States says we want to combat this criminal narco or whatever regime, they see that's our primary intent. Our primary intent isn't to harm the Venezuelan civilians. And I know that that's ridiculous, but unfortunately, that's the way criminal law works, both at the domestic level and the international level. There's also a kind of jurisdictional or obligation problem as well, because I guess many kind of economic and social rights obligations, like crimes against humanity, outside a situation of conflict, they're usually framed as extraterritorial. So the US is not acting within its own jurisdiction, but in another jurisdiction. So it's kind of its domestic or international obligations apply within its own territory, not when it's engaged in kind of military or economic statecraft abroad. So it makes it very difficult to say like sanctions or killing killing people in boats in the high seas constitutes an attack where the United States basically isn't occupying foreign territory because they could say, look, we're not in foreign territory where we've got like a court system and a military and a police. Human rights can't operate where we don't have an institutional presence. But we've got the kind of the UN Human Rights Committee and the American Court of Human Rights basically saying we take a functional approach. They took a functional approach to Cuba, saying wherever you're able to exercise power, wherever you're able to kill someone, then you've got the obligation not to do so. So that's like a key development there. But I think one of the principles is kind of it's very difficult to kind of make this out as a crime against humanity. So I think we could say that sanctions typically can be deemed to be lawful, but the crime against humanity claim is something that's kind of at the kind of cutting edge of law. But going back to the 1945, before the 1948 Genocide Convention, kind of genocide was a kind of a strange academic and political idea. And now it's almost like it's, a Newtonian law, if you like. We've got sanctions as crimes against humanity. We kind of think it out, we codify it, and we make it real. Just if I can go out even more broadly, for me, if I can just completely go outside of this, in that we're on this planet that I feel is dying, I feel that the American Court of Human Rights and also the United Nations Human Rights Committee is really kind of pushing forward kind of states and their failure to mitigate the impacts of climate change as a human rights violation. I feel that's another kind of cutting edge thing to look for. It's called the Torres Strait case, and this kind of new idea, this new state obligation that states have to kind of mitigate the impact of climate change and its impact on cultural heritage, its impact on kind of individual dignity. This is something new at the moment. People might say politically and especially legally, it's really kind of it's far out, it's cutting edge. But one of the things of normative development is things start out as within individuals. So like uh, genocide kind of started out in the mind of one man. Um, and then it gains political traction. Then it gets put into kind of political documents, gets put into legal documents. It gets institutionalized. And once it's institutionalized, I think it can be violated. But if any genocidaire wants to get rid of the law, then they not only have to do their deed in, the territory under their control, but they've got to come to Julian, your office, they've got to come to my office, and they've got to remove the books from the shelves. So good luck with that. They can't destroy this information, and it's there. And from my point of view, coming back to the statement you made, transitional justice is there, and it's got the concepts, it's got the mechanisms, and it can be brought to bear when the legal and political conditions are right. And it can take many forms. It could be a Nuremberg kind of international tribunal that's set up by kind of major powers, for example. Or it could be an independent international court like the ICC set up under a statute. What we saw with the ICTY and the ICTR was criminal tribunals set up under a Security Council resolution. And these are legal mechanisms, but they came out of a political origin, which is, to restore and maintain international peace and security. We could go down even further and say, you could have like mixed tribunals where, like Cambodia or Sierra Leone, where this is done within kind of a national system with international support. Or it could kind of go down even to like domestic courts. And this was, coming back to kind of hybrid warfare supporting General Pinochet. I mean, is that hybrid warfare? Is that political? No, I don't think so. I think that's basically, if you're supporting a proxy that wages war against a state, we could describe that as a kind of internationalized, non-international armed conflict. But Pinochet, his time came when he appeared before the domestic UK courts and then extradited to Spain. But then, he was given his due process, like many people are given their due process. When the bad guys are called to account, then they want the rule of law, don't they? They want their due process. They want rules of evidence and procedure. Yeah. They say that kind of convicting me violates my human rights. So I find it, you talked about irony. I find it quite ironic to see right back from the 1930s with the Nazi regime in its early forms, saying that attempts to control it kind of like violated their legal rights. And what proceeded to happen with Strelets, Augusto Pinochet, these people then try and say convictions violate the human rights. So I find that incredibly ironic that war criminals say that convictions violate their human rights. Why do they why don't they just stay quiet? Why do they resort to the language of human rights? But transitional justice, it's not only within we tend to think about, kind of international, regional, hybrid, domestic criminal courts. But I think your discussion of Rwanda was kind of fantastic in the sense that we can't expect the international system to deal with everything. We've got an international tribunal, and really it's only got the capacity to deal with like senior leadership. When we talk about IG Farben, maybe you can deal with all the people that were aiding and abetting it, the corporate leaders. But when it comes down to all the direct perpetrators, these people, senior leaders, they are not the perpetrators, are they? They are they are the kind of the planners. They're the commanders. They don't actually carry it out. So usually we try and say command responsibility, planning, organizing, instigating. The direct perpetrators further down, usually they'll be dealt with at the domestic level through criminal courts or maybe through truth and reconciliation commissions. But transitional justice takes many and varied forms, and the form it takes, I feel like, tends to be an outcome of, again, what's politically and legally feasible at the time. And that's kind of the demands from the international community, but also the demands are from individual communities. And that could be kind of, at a community or tribal level, it could be a regional level, it could be at the state level. And one of my kind of thoughts is that at an international criminal level, I think there is this tendency to say international criminal law, this kind of Western notion of international criminal justice with these rules of procedure is the way to do it. But I just think that kind of excludes, we've got a whole broad range of transitioning back to democracy, the rule of law, and peace. And I think sometimes, as kind of international criminal lawyers trained in a very kind of narrow sense, I think sometimes you just need to say, well, there are different forms of coming to terms with what's happened. And sometimes that includes, putting society on the psychiatrist's chair as well, rather than just being purely legal about it. That there needs to be this social and psychological reckoning. So I feel that as I get older, when I try and kind of work with or publish with some international criminal law journals, it is very difficult to say, look, that there are other approaches and other methods, because some people might take a very kind of narrow view of kind of what the law is and how to interpret it and how to enforce it. And this tends to be a very Western approach.
You're listening to Savage Minds, and we hope you're enjoying the show. Please consider subscribing. We don't accept any money from corporate or commercial sponsors, and we depend upon listeners and readers just like you. Now, back to our show. Jimmy Dore, the last 48 hours, has been running some clips about how certain media commentators introduced the then very young Britney Spears. And the sexism is off the charts, including by the Tonight Show, Johnny Carson's sidekick, Ed McMahon, which makes comments about her that are wholly pedophilic, okay? But this was allowed, and this was accepted in the 1990s on American television sets, right? Nobody said a thing. Sure, I bet the feminists were speaking out, but they were, of course, ignored. Now, I'm thinking to the outrage over the Epstein situation. And I remind people, sorry to be the bearer of really depressing news, but I've worked in child trafficking. Not as a child trafficker, by the way. When I was working with the UN in Haiti, I was working in the thick of it. And child trafficking is not new. And the head of child trafficking in Haiti was a woman within the Haitian government, by the way. And with the help from some mafia head. That was awful what I went through that year in 2010. But what I discovered is that it's a whack-a-mole. These are not new situations. Yes, it's great. We've got the evidence about billionaire classes, disgusting correspondence. But the thing is we need to also understand, you mentioned the Armenian genocide that most people aren't even aware about, because it didn't get the kind of Holocaustization that the Eastern Europe and German Holocaust received in the post-Holocaust era. Again, we don't hear about that. We don't hear about the 45 to 50,000 people of indigenous groups from the Quiche region in Guatemala who've been disappeared during the 1980s. Nobody hears about that. And I think it's really important that people understand that it's sort of that adage of, what was it, Socrates, that the difference between what you know and what you don't know. I think we need to understand that there is a whole panorama of human rights abuses. I argue with the feminists sometimes because they're talking about male violence against women. I'm like, dudes, there are men as we speak who are slaves on fishing boats in Southeast Asian waters, who will not ever see their families again. These are men who've been used as slaves. I mean, human slavery is not contained to sex trafficking either. You've worked in the field of international law. The human rights abuses are thick, and there are so many. Yet, here we are, 6 weeks after the Trump administration okayed a kidnapping of Maduro and Flores. We don't know what's happening to these people. It's almost as if they're in a black site in Brooklyn unto themselves. They're in a prison. It has a name. We're supposed to believe what we're told. I'm very skeptical after what I saw during the post 9/11 black site era, Guantanamo Bay, and then the 14,000 Muslim men who are characterized legally, in the States at least, by human rights lawyers as disappeared. These weren't just infractions of overstaying your tourist visa. These men were disappeared. In fact, they got a few Americans in the mix. I interviewed them and their families. So I think on the one hand, we're dealing with a lot of naivete, Michael, by people in the West who think, oh my God, I've never heard of this before, because it's like, wake up and smell the coffee. Because if you come from the global South, people know this happens. They've lived it. They've been living the neo-colonial reality TV show since people declared colonialism over. It's not. It's just shifted. And then on the other hand, I had on the show, in fact, a politician from Trinidad Tobago who invites me regularly to these conferences online, Zoom, because they're dealing actively with a peace agenda to try and bring cohesive unity amongst all these Latin American and Caribbean states against the U.S. aggression. And it's a really wonderful project that they're doing. But I am also, again, as I get older, I become more cynical, because I'm like, the man's going to squash this. How do you see the response across Western nations, right? I mean, this was the amazing part, is to see Macron, let's pick on him for a moment. He was in the second week of September in New York to declare how horrible this genocide is in Gaza, and he was saying all the right stuff, but then, of course, does nothing on that count. And when Maduro and Flores are kidnapped, it was another one of those. He wasn't really elected, and it was that kind of cha-cha-cha that is useless. Because people were looking, I think, were looking for leadership. People were looking for one EU leader to say, this is off the charts. Not we're going to invade, but just to make a comment condemning what Trump and his folks have done. Where do you see international law in this kind of theater? And then also in Gaza, also in Ukraine, where I'm sharing daily videos of Ukraine men being pulled into vans to be recruited into that war, which they're going to lose just by sheer numbers, which is also a proxy war of the US v. Russia. Again, it's all like out there, but legacy media is not saying it as it is. Independent journalists, we're saying it as it is. I think that's on par with what most scholars are saying as it is, hence the rise of voices like Mearsheimer and Sachs in legal scholars such as yourself, because we're in this era of a paucity of action, and then the words are sort of floating in the air. Where do we go from Macron saying evil words against Israel, sort of, in September and condemning that genocide, sort of, to condoning the kidnapping of a sitting ruler of Venezuela?
Yeah. So there's so many kind of important points there that really kind of just try and kind of, I think the work that you're doing is really, really important, just to try and scramble to kind of understand what are the conditions of life at the moment, what's the zeitgeist. And I think it's really important to pull together kind of lawyers, journalists, anthropologists, people in international relations to try and kind of make sense of what's going on. And it's very difficult to make sense of what's going on. In particular, you mentioned the notion of kind of hybrid warfare, so trying to achieve effects kind of below the threshold of armed conflict, and that could be through kind of various subversion operations, which could be kind of supporting kind of right-wing groups to kind of incite kind of ethnic hatred within a country, or paying off politicians to put forward talking points that kind of goes against the interest of your country or a particular alliance or a particular international organization. So, when you mention Epstein and how to respond to it kind of legally, I think I just first of all have to kind of go out of a legal frame of reference and go into a security frame of reference, which is kind of a form of like hybrid warfare known as kind of elite capture, which I guess is kind of a form of like, supporting proxies, but also controlling proxies to do your bidding. And I just have to be quite honest with you and just say at the moment, I am just completely terrified about the extent of, sexual crimes and violence that have been committed against young women. And it seems to go beyond kind of ordinary criminal activity, kind of like trafficking and rape, as you mentioned, up into the kind of the level of being almost a crime against humanity. And what's really scary for me is, as you know, how in the United States at the moment, for whatever reason, is it, media control? Is it trying to kind of deal with the daily, I don't know, that trying to work out what the executive is saying or doing is a minute by minute activity to understand what's happening and then to try and classify it. What's, previously what would have happened, once every 12 months is now happening once every kind of 12 minutes. But in the UK, I think at the moment it's exploding because we've got, political accountability, but also increasing legal accountability when we look at, former Prince Andrew, but also Peter Mandelson, who was under the Blair regime and then under former Prime Minister Brown as a kind of Secretary of State for Business. And just to show how this basically Peter Mandelson, kind of a person who was a corporate lobbyist, and how he was completely compromised by Jeffrey Epstein by somehow getting compromat on him. These really kind of exposing photographs of him. And it's very, very worrying to see this person. And it's very difficult to understand, with intelligence operations, it's very difficult, isn't it, to kind of say kind of to detect them, first of all, they're kind of covert or clandestine. Then when you detect what's going on, then kind of who's behind it, which state or non-state actor or organized criminal group is behind it. And then how do we kind of respond to it? And the scary thing to me just seems to be this kind of hybrid warfare notion of elite capture. You've got United States capturing elites within Latin America. Kind of Maduro is gone, but his regime is still there. And what form is control taking? I find that very difficult. I don't have the information to say, is this a form of occupation? Because it seems as if the government there is consenting, but from an international lawyer's point of view, I just think consent obtained under force is not consent. Territory acquired under force, Venezuela, uh, Gaza, Ukraine. We go back even further, South Africa and Namibia. The international law basically says acquisition without consent is not lawful. You can dress it up how you want, law enforcement, consent, but our holding pattern is we won't recognize it. I feel comfort in International Court of Justice in Namibia, just to say, like, even though South Africa tried to dress this up and formalize it, international law just basically says, no, no, no. If you acquire territory or consent, if you acquire territory or consent, with force or coercion, it's void. And the logic of that isn't just international law. You could look to Italy, United Kingdom, America. If you try and get someone to transfer their property to you and you get them to sign the deed, but they sign the deed under fraud, duress, or coercion, our point is, well, like this transaction is voidable because you used consent and, working in domestic property law and then working at the international level. I feel that it's that kind of core logic really that applies. So I feel like going into the hybrid warfare, I think this notion of elite capture, I think that's very worrying. And this notion of this person putting kind of business people and political leaders and the transition from political leadership, so business to politics, Trump is, like a fluid one, but it's really worrying to see how these people can be captured and compromised and allowed anywhere near government with control over people's lives. And as you note, their criminality was identified early on. Their their um their connections potentially with kind of compromised people in foreign states or intelligence agencies was noted early on. So I'm just outstanded that in Britain and the United States, there just seems to be a major failure of counterintelligence. And I just wonder how we're going to be able to get out of this and put back guardrails when it seems as if these people, as you know, on the public record, not just in the time of social media, but we could, with Trump and Epstein, this goes back, doesn't it, to the 1980s and visits to Moscow or the 1970s, and it's always been there, but somehow we're not able to use this information to protect ourselves from these forms of kind of malign interference, this malign influence. Maybe the focus is like China and transnational repression, Iran and transnational repression. They've got these media fronts, and we need to shut them down because of their threat to national security. But then what are our blind spots there? And I think that Epstein is a major blind spot, and I'm just shocked that it's happened. So I just hope that we continue to try and bring everything out into the open. And is this dealt with kind of through, you know, criminal proceedings at domestic levels? Will we have public inquiries into this to ensure that it never happens again? But I think the important thing, as you know, is this goes beyond ordinary criminal activity within a house in Palm Beach up to the level of a crime against humanity. And again, kind of, you've got the Inter-American Court of Human Rights, and you had one of the seminal cases, which was the cotton pickers case, just looking at how the Mexican government, in cahoots with organized crime, the kind of the foreign intelligence aspect doesn't feature, but this impacted on violence against women in terms of trafficking, in terms of gender-based violence, and in terms of killing them. And this case kind of brought it out into the open and forms part of transitional justice. So the cotton pickers case, the case of Velasquez against Honduras, again, I thought that case, 2008, I think it was, so important, dealing with the aftermath of a dirty war and looking at this kind of state pattern or practice of disappearances and the struggle of kind of dealing with these very grey zones where we don't have evidence about trafficking or murder and its connection with crime groups and their connection with states. Human rights mechanisms are in a very difficult position. They don't have the evidence to deal with that. But with the case of Velasquez Honduras, I think the approach there was like, well, state, if you have, and this rings true now, doesn't it, with the Epstein files and many of them being deleted? Well, state, if you've concealed evidence or destroyed it, we're going to draw adverse inferences against you. We find that this broad pattern or practice, and there's evidence of that. And we've got these individual cases with evidence that's being concealed or destroyed. Well, if these specific instances fit within this broader pattern or practice, then we can say, well, actually, there's a connection there or there's a link. And our goal is not individual prosecution here. Our goal is kind of state responsibility and to transition back to the rule of law. So I think even if we don't have kind of international tribunals or national prosecutions, individual criminal responsibility that can really take that kind of under the microscope look at the individual and their state of mind, can look at their bank accounts, can look at business connections or associations, can look at flight manifests, kind of international human rights mechanisms, state responsibility. They take a much kind of broader, less focused point of view, but sometimes that is important in moving on. And there is always that difficulty of what do we do going forward? Do we move towards kind of peace and reconciliation, or do we move towards justice? Which takes me back to a kind of a formative memory that I have working within the ICTY. So with the ICTY, again, it took Nuremberg out of the freezer and developed all of the general vague rules to make them more specific. The first case, Tardich, Tardich concerned a detention facility that was kind of basically it involved sexual crimes against men. I mean, it was also concerned about, does the international community have jurisdiction in this conflict? And does the international community have jurisdiction to prosecute individuals for these crimes? But under that was basically a detention facility where you had all manner of of kind of predatory acts against men taking place, but not just men. The ICTY really took out this notion of, you've got this word rape, and it took this word rape and articulated that so much more clearly to kind of not only see but recognize what was going on. Rape isn't just an isolated act by one soldier against a woman or a community of women. It's part and parcel of a kind of illegal war. It's part and parcel of crimes against humanity, a widespread and systematic attack directed against the civilian population. It's not just against women. I mean, it is, but it's against that community. It's a crime against humanity, but also it's a form of genocide. Making that link, going back 50 years, it's like we didn't even have the notion of genocide. So I think these words help us see the forms of kind of brutality, the forms of harm that can be brought about. And I think it's really important, not just from a legal, but also anthropological or social scientific point of view. The more words we have, the better it is we can identify it and do something about it. People we come back to that notion of international laws isn't working, international mechanisms are not working because we're seeing all of these breaches. And I mean that's true. I mean, last week we've got the Geneva Academy again, the report, War Watch, that's just documented hundreds of thousands of potential war crimes, Sudan, Ukraine, Democratic Republic of Congo in the past 2 years, and we've just ceased to be able to do anything about it at this moment in time. But for them to be able to do that shows that this civil society actor, but also its connection with the United Nations system, European systems, they've got the ability to engage in monitoring, reporting, fact finding, using the language, using the techniques to uncover this. And in one sense, we've got this notion, and I really like a writer called Catherine Sikink, and she wrote a book called Evidence for Hope, Making Human Rights Work in the 21st Century. And she said we shouldn't just take a legal perspective on this, we should take a social scientific perspective. And in the social sciences, she mentions kind of certain biases that we need to identify. One is invisible harms, and then the other is the information paradox. And the information paradox can lead us to kind of sometimes kind of problems with our thinking. And she mentions, the crime and the social harm of rape. And she says, if we look at certain countries, for example, Sweden, then we can see that there's a massive problem with rape in these countries. If we compare it to, let's say, Brazil, then there's a massive phenomenon of rape in Sweden, but not in Brazil. Does it mean that there's a failure of Sweden? And she says, well, no, because Sweden, it might just indicate that they've got the rules and they've got the procedures whereby it can be reported and it can be investigated, and then convictions or acquittals can be put on the record. The far worse problem is in maybe certain countries, and she mentions Brazil in that example, where we don't have that ability for victims to report the crimes. So we've got that invisible harm. So just because, as you say, just because, things seem to have been okay for the last 30 years, well, I think both of us through our various networks, for me looking at, the kind of the prism of the law, I just feel like for the past 30 years, for me, the kind of Iraq and Afghanistan, it's been an ongoing nightmare and a trauma, really. Just, seeing this system of kidnapping and secret detention sites. And then I think, oh my gosh, I look at other cases like Velasquez Rodriguez against Honduras and think, oh my gosh, that goes back even further to the 1960s. So I think it's it's all there in the record. We just need some point, and at what point do we get to that when you know a generation draws the line and say we need to come to account with that, and then the question is kind of what do we do about it? Do we have these legal approaches, or do we have kind of social psychological programs? And that's just the last kind of spin-off point I would like to make, responding to your point, which was when I was working at the ICTY, I was working with prosecutors and investigators dealing with the most horrific crimes committed against women and men, all as part of this geostrategic policy to create a greater Serbia. Yeah. Where we've got this federation that's collapsed. We've got the remains of it, Serbia. We now want to create enclaves in these countries. And to do that, atrocity crimes are committed. So there's no difference between crimes against civilians and the war objectives there. And I was working with an investigator, and he said, like, we've spent £2 billion on this, in like speaking with these people, and now that it's coming to an end, we've got these buildings, and we've got all of these cars, and we've got the books, we've got the phones, we've got the computers. It's all, it's all going to be like sold off at undervalue, or it's going to be put into a skip. I just feel really bad. Why don't we kind of give these things to these groups of rape survivors? Why don't we give them all of these resources so that they can support themselves, so that they can understand what's happened, so socially and psychologically they can progress? And my response to him was like, well, we need the kind of criminal law process to put it all under the microscope and uncover the system of criminality, to bring it out into the open, not just at the general level of state responsibility, but to kind of to look at the bank accounts, the finances, the money transfers, who said what, who did what, to bring that out into the open. But the whole kind of working at the community level, that's not kind of, international criminal justice shouldn't be to the exclusion of that. Surely our understanding of human rights protection, and I like the International Committee of the Red Cross did a report called Professional Standards for Protection Workers, and it says, we've got this modular approach and we need to kind of join it up and make everyone work together. And the kind of that is a very kind of situation or context specific thing. The kind of the needs of one group or victim group in one country might be different from another, and we should take care to ensure that we're not focusing on certain victim groups or communities. We should ensure that we're not being manipulated. For sure, we've seen that in Afghanistan. Maybe that's why it's failed. All of these programs for education and healthcare and development, there was manipulation going on there, and we didn't realize that actually there was this kind of corruption there that needed resolving. So I think it's kind of making sure that in trying to do good, you don't create more harm. And yeah, in the context of the Balkans, I just remember that so many kind of difficult dilemmas of protection where you've got peacekeepers going in and thinking, what do we do? We've got civilians here that are being subject to kind of, a crime against humanity, ethnic cleansing, rape. Shall we evacuate them? Let's do that. But then the problem becomes, well, you've become complicit in that campaign now. You've evacuated the people, the territory is taken. How are we going to get them back in the future? So you've created new facts on the ground that needs to be resolved. You know, Kosovo has not been resolved. Occupied Palestinian territories, settlements, we could say no. Facts on the ground, maybe it becomes a frozen conflict, but I think the international law point of view, as ever, is kind of consent obtained under coercion is not consent. Territory acquired with conversion, with coercion is not the lawful acquisition of title. And I feel like holding on to that, I feel like it's worked in South Africa. I feel like it's worked in Chagos. But the problem is I feel that we need like universality in applicability and universality in application. But I think you're spot on to say that it's been very uneven and very selective. And I'm not sure how we can coordinate ourselves to ensure consistency in an international system. How do we achieve that? Do we have a global government and an international court? If we do that, are we going to undermine the system that we've already kind of created and is in some respects effective? It's not effective in the sense that we want putting people in prison, but it's effective in the sense that it's gathering that record, it's bearing witness, and it's creating that record. And with that knowledge, we might not be able to do something now, but will the situation be different in 30 or 40 years? If we've got the accounting now, that makes that so much easier in the future. Because if you don't have that, then there's that difficulty of kind of it's not trying to demonstrate what you know, it's trying to demonstrate what you can prove. And if we kind of keep all the facts now, that makes that educational, social, historical, but also the legal reckoning so much more important. And I feel international criminal justice shouldn't just be a kind of a legal phenomenon. I feel it's a much broader kind of historical and educational enterprise. And I feel very grateful that if I'm working within, a refugee agency trying to help people um get refugee status or asylum, I'm able to have this telescope to see exactly what is happening in Sudan or exactly what's happening in Guinea. And I don't feel that, as a species, sorry to say, like I don't feel as a species we've ever been able to kind of do things like that, have that shared language and have that global observatory. But having that observatory kind of, how do we engage with it? How is it funded? Is another thing. And I come back to that earlier point. We've created this kind of international system, and if we didn't have it, then I feel like we would need to create it. And I feel that was the League of Nations to the United Nations. Once we've created it, do we give it the people and the resources that it needs to do its job? And honestly, no, it hasn't. We look at the UN treaty body system. Again, we've got the Committee on Human Rights, Committee on Elimination of Discrimination Against Women, Migrant Workers, People with Disabilities, and Forced Disappearance. You know, um, I look at Sheriff Bassiouni, a former lawyer, and he said, well, the budget for this global system is less than the budget for New York City. So you've got this kind of system with a global mandate, but with a budget less than a essentially. And I think we need to kind of bankroll it, and we need to support it. And we do have examples of that happening. So Sheriff Bassiouni really wanted to investigate crimes taking place within the Balkans in the early 1990s. And he wasn't able to get bureaucrats to support him. And if they did support him, he wasn't able to like get money from the UN Secretariat. So Sheriff Bassiouni, doing the early commissions of inquiry into the Balkans before we can get the resolution, before we can get the political mechanisms to agree and resolve, before we can get the legal mechanisms to do something about it, before we can get the kind of the post-conflict transitional justice. He didn't get finance within the United Nations, so he went to I think he went to the University of Cairo, and he got office space and computers from them. He got funding from civil society actors, so he was able to start kind of gathering information of rape as a crime against humanity, ethnic cleansing. He was able to get it on the record somehow, maybe in the kind of the post 1989 space, that was able to get some political traction at the time, both regionally, Organization for Security and Cooperation in Europe, and then internationally, General Assembly and the Security Council resolution to recognize this as a threat to international peace and security, and say, to put this right, this involves a criminal court and lifting the bad guys out of an active armed conflict and putting them into prison. But that is just one way of doing it. And if that's kind of our be all and end all of international law, I feel we're going to be very disappointed, because I feel that there's a much broader range. And your notion of Rwanda and kind of like customary processes for accountability, reconciling what's happening or happened, South Africa, transitional justice. I feel these methods are important as well, and they should not be lost in this kind of, I feel like, what is a very kind of like Western approach to professionalize human rights law and international criminal law. I think that that's good because it makes it legitimate. If you have these standards and this methodology and you adhere to it, it makes it so much more difficult for states like Israel to say, look, we're not going to accept your findings because you haven't reached out to us to see what we think first. So it's good in that sense, but I think it's concerning in the sense that it can exclude kind of victims, victim communities, journalists from carrying out their investigations, and the media and civil society doing something about it. But then again, the media, civil society actors need to ensure that they're not being manipulated. They're not going to be criticized as, doing black ops or psychological warfare themselves. But also, if you're gathering evidence on crimes against humanity, like forced displacement of civilians, rape, you need to ensure that your kind of your intelligence or your reporting is not later kind of dismissed by an international court or investigator because somehow you've been compromised. So I think it's really important to have this kind of broader conversation, and I really appreciate the work that you're doing to bring together all these different thinkers. I think that's so valuable. So thank you.
No, well, thank you. I'm really disturbed by the fact that a lot of what we are facing in recent years is this crossroads of where international governments in their own domestic zones, legacy media, and even certain actors that could be anything from NGOs onward to private organizations have created this obfuscation of history. I'll give you two examples. The Monroe Doctrine, many people believe is a law. I'm like, no, duh. It was more neo-colonial nonsense. Well, colonial at the time. It was a statement of what at the time was regarded as U.S. foreign policy, like It's what kids did when I was growing up in southern Canada, and they drew a line on the sidewalk, and you can't cross this line, that's my property. The US pulled one of those, and then you've got the Balfour Declaration over there, where people from your side of the pond decided they were going to divvy up places that weren't theirs, but let's forget about that. I feel like, even though they're not really related, except maybe an ethos of a kind of Western imperial prerogative, both these moments of the Monroe Doctrine, the Balfour Declaration, set up a kind of future ethos that we now are facing. And in the case of Gaza and Israel, or just say Palestine, Israel, the genocide has been ongoing even before October 7th, in my view. It was a slower genocide. When you start to look at the numbers, and I did research on this, it's approximately 1 million Palestinians that have been imprisoned, mostly without trial, in Israeli prisons since the creation of the State of Israel. And you look at the human rights abuses there, and I'm talking before 7 October 2023, you look at the ways in which apartheid was fully cemented. There's a reason why the wonderful Desmond Tutu declared that this was something far worse than had ever been executed in South Africa. And you look at this, and then I see what even some lovely friends of mine in the UK are still saying, but Israel has a right to exist. And I'm thinking, holy cow, you're positing genocide on this side and Israel has, like, they're not really related. Stopping a genocide isn't calling into question the right or not of Israel to exist. It's about genocide. But this has muddied the waters. And the Balfour Declaration seemed to set up this idea that this was somehow a law. It's not. It wasn't. It was never. And that what has happened in the development of the State of Israel, being the quote unquote only democracy in the Middle East, has allowed so many people in various fields, including television pundits, to claim that Israel must exist because it's the only democratic nation in the Middle East that is setting out the standard of future human rights. I mean, it beggars belief, everything. You've seen it. It's everywhere. How did we get here such that historically no one's ever really butted heads with not Trump, but any kind of history maker or American policy maker saying, wait, back when we kidnapped Noriega, wait, the Monroe Doctrine isn't really a thing that you can act on. Or the Balfour Declaration, where we've seen it. It's not just Francesca Albanese. Even prior to her, you've had decades of even Israeli scholars saying, this is wrong. We cannot occupy these people. We cannot keep them from having drinking water, etc., etc. How is it that this has developed, that there hasn't been a full stop officially? And officially doesn't necessarily mean through the ICJ or ICC. It doesn't mean through the Hague at all, actually. It means very likely through, I'd have to say, the universities in which you and I have taught, that universities in the West start to recognize that Palestine deserves statehood, whether it's the one or two state solution, that the Balfour Declaration was a colonial disaster, and it did not right a wrong. It created two wrongs.
Yeah, I think the point that you made earlier, I think it's just it's heart-wrenching really to see kind of one historical injustice can lead to many more further down the line. And perhaps we have historical injustices that occurred in the 14th century and how that leads to ethno-nationalist crimes and atrocities everywhere from the Balkans to the Middle East. And one of the things that I feel we need domestic law and we international law to engage in kind of political discussions and compromises that are consistent with international norms, but also kind of individual and collective rights. And this is achievable within the system of United Kingdom, within the federal system of the United States of America, and maybe within the kind of the European Union as an intergovernmental phenomenon where we have some type of union or federation that exists on top of a plural society, different races, different ethnicities, different religions. This is something very achievable. It's very possible. So this kind of notion of a kind of ethno-nationalist project being imposed on a geography that's very plural, I think is just deeply concerning in that to achieve that involves atrocity crimes if you've got that pure ethno-nationalist vision. And I feel that it's happening in many places, and also kind of one crime or injustice leading to another. I think the Syria example that you gave was really important because I feel that in a way that for me that kind of partly comes out of Iraq and Afghanistan, where you have refugees kind of forced to leave these conflict zones and going into Lebanon, going into Syria, and then the kind of the the ethnic, economic, national tensions that creates the basis for a new conflict elsewhere. India, I guess, like partition as well. I mean, the you wouldn't have called it at the time, a crime against humanity, but now we're able to kind of see it through that perspective. But you impose a border because you want to try and exit like colonial rule, and you put that border in place, but there's one ethnic group on the wrong side, and then people feel that we've got this kind of state sanctioned policy that enables us to kind of take it into our own hands and commit these offenses. So, just in terms of these doctrines, ethno-nationalist, um, a Jewish democracy imposed on a geography that is plural and with a long history of plurality. Um, a geostrategic policy, the Monroe Doctrine. Again, it's just important to stress, isn't it? And to articulate that through international law a little bit later, but it's always been a political doctrine, not a legal doctrine. Developed in 1823 by James Monroe. And I guess kind of like warning the European powers against colonization in the Americas. So we could say this is a unilateral policy declaration, not a treaty. It was never negotiated, it was never ratified. It was at a time, I guess, when kind of international law was thin to the extent of non-existence. And also it was developed at a time when we're not a multipolar world with China being such a kind of economic power with kind of with economic leverage in ports, energy, infrastructure throughout the world. So the Monroe Doctrine, you could say, yes, realism says this is a thing, international law is not a thing. But you could say, well, the Monroe Doctrine, from a realist point of view, is kind of outdated because it might have been a product of kind of geopolitics at that time. But now, if you want to try and do that, then you're going to have straight away Canada and China hedging against you. They're going to kind of use like new or existing bilateral or multilateral mechanisms to promote cooperation and trade. So it's absolutely, outstanding kind of China saying that United States is violating international law. So we could say this old wine in new bottles. It came before the 1945 charter system, and it simply can't really coexist with it. So after Yalta, remember Churchill, Stalin, Roosevelt, creating the framework for the San Francisco Conference and the creation of the UN Charter, the UN system, sovereign equality of states. You can't use force to undermine territorial integrity, prohibition on the use of force, non-intervention, collective security, self-defense, only under Article 51. That conflicts with the Monroe Doctrine of this notion of kind of a hemispheric sphere of influence, kind of special US prerogatives and US exceptionalism, you know, quite incompatible with this kind of this post 1945 system created by Russia, United Kingdom, United States. So I guess it belongs to a 19th century world of empires and spheres, not the kind of the modern system. And we can see even before the kind of the Monroe Doctrine. I think a while ago you mentioned the Drago Doctrine. So even at the time, I think the history books kind of indicate that Latin America did not passively accept this as a kind of valid political or legal norm, and they had their own kind of like regional political or legal doctrines to limit it. So especially kind of Argentina opposing the use of force and kind of explicitly resisting kind of European coercion in Latin America. And I think that's what created the impetus for, Latin American countries to engage with the San Francisco Conference and kind of say like, look, self-determination, sovereignty, human rights are things that we want to kind of have recognized in this international system. And, the kind of the Yalta Conference makes it looks like a kind of Western thing, but I think the history is the global South really struggled for a lot in this kind of UN system. And I think kind of the Latin American kind of political and legal developments, kind of 1948, like the um the American Convention on Human Rights, that happened before the UN Declaration on Human Rights and before the European Convention. So they led the way on that with non-intervention norms, sovereign equality, prohibition on the use of force. But later on, I think kind of moving back to the kind of the territorial point, I think the Monroe Doctrine just straight up incompatible with international law and under various US doctrines. They would agree with the point that I'm going to make, which is, modern international law, territory can't be lawfully acquired through the use of force, and the use of force doesn't alter sovereign title. We've got the Namibia advisory opinion, and this is something that we can hold on to, which basically says, like South Africa's presence in Namibia was illegal, and states had a duty not to recognize this unlawful situation. And I think that applies now. It could be Greenland, it could be Venezuela, it could be occupied Palestinian territory, but a duty not to aid or assist that. And international law recognizes that force can create facts on the ground, but it simply doesn't create lawful title. You can do what you want to do and justify it yourself, but at some point in time, you're going to get old and die. Your political idea will get old and die. And international law has that kind of holding mechanism. So from Namibia to Chagos, I think international law, for me, can operate on a longer time horizon than geopolitics. And power can temporarily dominate. But from what I've seen of various cases going back to the 1960s, and even now, I feel like law can exist to preserve claims. It can record rights and wrongs, even when it can't immediately reverse them. So I think Monroe seems to resurface at moments, um, but the legal framework established in 1945 doesn't ebb and flow. You could have some people that want to try and switch it off unilaterally, but because the international system is beyond the control of anyone authoritarian or anyone malignant narcissist, if we can put it that way. I feel that's the beauty of international law. And we do want a kind of a world court or a world government to respond to the global challenges that we face ourselves, rising above everything we've said. I feel like it's planetary death for me is something that, with children, I feel like I start to have panic attacks just about the earth dying. I feel confident saying that now, going back to 2002 when I started to read the reports from the Intergovernmental Planet on Climate Change. I just thought I'll just be quiet about it. People might think I'm saying too much, but they had predictions for 2050, but to see it now is very scary. So just going beyond the kind of the Monroe Doctrine, I think it conflicts with the charter logic about the system prohibiting force, collective security, and non-recognition of unlawful title, but also the charter logic of kind of multilateralism. We've got challenges that need us to talk together and respond collectively. Multilateralism. I don't believe that the Monroe Doctrine autocratic legalism, I do not believe that can survive the conditions that it faces, which is planetary crisis. I have the feeling that somehow we will need to collectivize to be able to respond to that. In my country, United Kingdom, the problem is flooding, and we have a situation with local authorities simply having to kind of like buy up land from communities because people can't get insurance to live there anymore. For me, that says, well, the economic system can't respond to it. The community, the state needs to intervene to respond to it. And if it doesn't, it's going to have major problems. So if I can just like come back to the question of this notion of an ethno-nationalist state or project being imposed on conditions that are anything but that, a plural conditions. Can you have an ethno-nationalist project that's democratic? And also I think that the broader question is, if you try and pursue an ethno-nationalist project, isn't that somehow kind of against your own best interests ultimately, not just from a moral point of view, but from a practical point of view? And if we could say 2026, we've got the end of the rules-based international order. Well, I think what we're both kind of saying here now, based on the literature, based on the reporting, is the international system was created in 1945, but since 1948, we've had this ongoing, some people say, silent genocide, which is an outcome of a botched colonial project, as you noted, the Balfour money. So I think it's really important just to quickly take stock of that, just to say how, on the one hand, we've got this system that just tries to accommodate the complete antithesis of the system at the same time. But for the past 80 years, you know, we haven't said this means that we don't have an international rules-based system. So I feel like I can just do a kind of potted history, if you like, in about kind of 7 steps that kind of encapsulate why we shouldn't be fatalistic and why we shouldn't despair. So I feel like from the period of 1947 to 1966, you kind of note that we've got the Balfour Declaration, so another botched partition, and we've got armistice. And during this time, we see the growth of this norm of self-determination that didn't exist, but this gives us the language to understand and to try and do something about it. So we see this concept of self-determination entering the UN system, and the UN Charter embeds this principle of self-determination, while Palestine is still formally mandate territory, trying to transition out of a form of colonial administration. So this gives us a kind of political and legal tool to try and kind of go towards like a pathway to settlement. And then we have political intervention from the General Assembly in 1947 that proposes partition. So we could say this is political. And legally speaking, it's a recommendation, not binding law, that reflects this emerging norm of self-determination, but that in itself doesn't create statehood. From 1948, we have the 1948 war or Nakba, and then I guess international law now starts to kick in and basically saying there's a prohibition on acquisition of territory by force. So even if Palestine is not formally recognized as, territory, still this is acquisition of territory through the use of force. We see massive refugee displacement. And immediately, this activates kind of norms about refugee protection and the right to return. So, General Assembly Resolution of 1948, so important to hang on to that, to say, you've got this right to return. You should be permitted to do so or receive compensation. So, right from the beginning, the legal framework speaks of the language of self-determination and refugee rights. The armistice lines, the Balfour Declaration, not final borders, but international law says there is that kind of that territorial right that can't be taken from you through force. And then we go into the period of, I guess, 1967 to 1987, where we see the application and development of occupation law and the law of belligerent occupation. So I think the 1967 war was a legal turning point because, during this period, we see Israel occupying the West Bank, East Jerusalem, Gaza, Golan, and the Sinai region. And from this, we take kind of international law from the Hague Regulations of 1907, and then more recently, the Fourth Geneva Convention of 1949, that just basically says kind of occupation of territory doesn't transfer sovereignty to you. The occupier, the occupying territory can administer territory, but this is a temporary phenomenon. And when you're doing that, the occupying power simply cannot transfer its own civilian population into that occupied territory. It can't change the rules of that occupied territory. It can't transfer property into different ownership. So annexation is unlawful. And we have political recognition of that. UN Security Council resolution in 1967 says acquisition of territory by armed conflict is inadmissible. And the UN Security Council at the time able to say kind of we mandate the withdrawal from territories occupied in recent conflict. So there's this respect for sovereignty and territorial integrity. So from 1967 onwards, international law has treated the West Bank and Gaza as occupied territory, no longer disputed land on the basis that you've got this political Balfour Declaration or this Green Armistice line. So that's really important. It recognizes the factual reality, which, from a property lawyer's point of view, you've got that territorial claim that can't be taken from consent. And then we go into the 1980s, and then we have more settlements and annexation. And we have another Security Council resolution 465 that declares that settlements simply have no legal validity. You can create facts on the ground, but this is not something that is legally recognized in the long run. UN Security Council Resolution 478 then rejects kind of Israel's kind of application of basic law on Jerusalem, calls on states not to recognize it the same way states had a duty not to recognize South Africa's acquisition of territory in Namibia through the use of force there. So it's kind of not controversial to say that there. It's not controversial to say it here. That this is the UN Security Council saying this. It's the International Court of Justice saying this. States have consented to these norms. States have consented to these mechanisms. So I think this is important because by the early 1980s, we go from like political to legal consensus that settlements and annexation was already fully articulated. And then we go into the time when I started to kind of wake up and see the world, which I guess was 1993 when I was in primary school to 2004 when I was at university. And the political process of the Oslo Accords didn't suspend occupation law. And I think it's really important to kind of to note that you've got peace processes and political processes that can't be used to displace this kind of ongoing legal determination. So they created partial Palestinian self-rule, but international law still remained, regardless of what concessions could be gained through this kind of through Israel, with United States acting as kind of Israel's lawyer in these negotiations. And the international law position at this stage was occupation law still applies. Fragmentation of areas of Palestinian territory into areas A, B, and C didn't end that. And effective control remains decisive. So at this point, we have the 2004 International Court of Justice advisory opinion. Again, many states might say advisory opinions not legally binding, and I guess that's correct, but it still has legal force. And the court said the construction of a wall inside occupied Palestinian territory was unlawful. The settlements violate the Fourth Geneva Convention and the right of self-determination to decide your own political, social, economic future. And the International Court of Justice said that Israel had to cease construction and make reparations, and that third states shouldn't recognize this unlawful situation. So in 2004, the International Court of Justice didn't treat this as a temporary security problem. It treated it as a structural violation of occupation law coming from the 1949 Geneva Conventions, and now the kind of crystallized norm of the rights to self-determination, this political process to decide your own future and have that articulated. We kind of come forward then to 2005 to 2004, the so-called Israeli disengagement from Gaza, but the blockade of Gaza at the same time. So apparently, Israel removed settlers from Gaza in 2005, but still has occupation ended? Well, I think international law kind of questions whether or not, even though you've removed settlers or military, are you still in effective control? So during all of this time, we could say Israel still retained effective control and had obligations under international law not to move your civilians into occupied territory, not to change the law, not to violate the human rights of people or domestic law in that region. Israel exercised effective control because it's simply not controversial that it retained control over airspace over Gaza, maritime access, retained control over the borders, except the Rafah. It maintained a population registry. It controlled utilities like water. So I think most UN bodies and legal scholars still treated Gaza at this time as occupied. And the blockade, we could say, raises kind of separate issues as a kind of a form of force. And even in times of armed conflict, we could say like a blockade could amount to a form of, criminal activity like the starvation of civilians, which is prohibited. And also kind of Goldstone in 2009, I think really important political mechanism there. That's actually kind of applying all of these rules to find out what's going on and kind of really talking about kind of targeting practices there and civilian harm and possible war crimes that just leads to where we are now. 2012 to 2021, the International Criminal Court finally enters the picture because in 2012, Palestine became a UN non-member observer state. And in 2015, that enabled Palestine to accede to the Rome Statute. And the International Criminal Court then accepted jurisdiction back to 2014. So that just goes to show that this is transformative because you can try and control the narrative. But because of a fragmented system, you're not able to do that necessarily. And at this point, we've got the International Criminal Court saying that alleged war crimes in Gaza, West Bank, East Jerusalem fall within ICC jurisdiction. Settlements may constitute war crimes. Crimes by Palestinian groups as well also fall within jurisdiction. And the ICC confirmed jurisdiction over West Bank, East Jerusalem, and Gaza. So we go from kind of diplomatic condemnation to the kind of the application of the kind of criminal law accountability architecture. Coming to kind of now, let's say 2022 to 2024, we had the kind of ICE International Court of Justice and the genocide case. So individual criminal responsibility mechanism activated, state responsibility mechanisms activated. We saw this in Serbia in relation to the genocide in Bosnia. You had criminal proceedings and you had kind of state responsibility before the ICJ. So the Security Council couldn't operate, but nevertheless, the General Assembly intervened here and requested the International Court of Justice to give an advisory opinion. So the 2024 ICJ advisory opinion, and it's worth looking at legal consequences arising from the policies and practices of Israel in occupied Palestinian territory, including East Jerusalem, said prolonged occupation, unlawful, settlement enterprise, unlawful, annexation measures, unlawful. Third states should recognize this, and states must cooperate to bring this situation to an end. And then simultaneously, you had South Africa bring in an action against Israel under the Genocide Convention. And the ICJ found here that, the Genocide Convention is at risk and it ordered provisional measures to prevent genocide and to allow humanitarian aid and to halt certain operations. So we've got judicial intervention now. And coming up to the present, 2024 to 2025. So in May 2024, we had the ICC prosecutor applying for arrest warrants against the Israeli leadership and also Hamas leadership. In November 2024, and this is quite unprecedented, we had another sitting head of state, the Israeli prime minister, with arrest warrants and also Hamas leaders. So I think the legal significance of this is that war crimes and crimes against humanity now are being activated, and arrest warrants have survived early jurisdictional challenges, and states party to the Rome Statute have duties to cooperate. The only problem with that, again, and we come back to hybrid warfare, is state operations have been kind of targeting kind of ICC officials to block bank accounts, asset freezes, travel restrictions. So we see all of these efforts to try and shut this down, whereas, going back to the 1990s or going back to the immediate period after the Second World War, they were actively supporting it. So these doctrines seem to change over time, and even though something is put into the freezer, things can be taken out and things can take time. So I feel like it's important to say, kind of from an international point of view, after nearly kind of 80 years of UN engagement and 60 years of occupation, we've got that holding pattern that we can maintain, which is territories are occupied, no matter what you try and say in this political agreement with the Board of Peace. The settlements are unlawful, annexations unlawul, prolonged occupation violates rights to self-determination. Third states must not recognize or assist a situation. There's a plausible risk of genocide. So bearing in mind that, law is very cautious. It needs kind of evidence, and there's what we know and what we can prove. So that's very unsatisfying. War crimes and crimes against humanity under investigation and arrest warrants are enforced. So whatever the one's politics, and we can both be criticized from a range of points of views here, but I think the legal record is there. It's not thin or ambiguous. It's consistent. The gap's not in the kind of the development and articulation of norms. It's kind of enforcement here.
And this is, of course, the worst part of all, is that, as you've mentioned, and I've referred also to alternatives like the Gachacha or the Truth and Reconciliation Committees that have been used in the Southern Cone to address the disappearances, 30,000 in Argentina, much less, but still disappearances in Chile. What are the alternatives? Grassroots building networks, liaising with local and regional politicians, hopefully that the situation, whatever one of the thousands now that exist, might be remedied. In the case of the ways in which certain countries seem to be able to wield their power, however, Michael, this is another problem, because as I was telling someone recently, it's like if the US were a flatmate, we'd be kicking it out. Right? That the U.S. would be raiding the refrigerator, never cleaning anything, constantly bullying the other flatmates. We wouldn't have it in our flat. However, it seems that the rules-based order is not only dead, it's been dead. I mean, what the Canadian Prime Minister said was sort of a nothing burger in terms of information for those of us who knew that this was the status quo for many years. This isn't new. He was, in a way, capitalizing on the elephant in the room. It wasn't just an elephant in the room. It was an elephant that had defecated all over the room, and people have been pointing this out. However, what do we do with nations like Israel and the U.S. that seem to have carte blanche in and around every corridor of legal and political efficacy?
Yeah, that's right. And I guess, it is nothing new. I guess people who were living under the Soviet regime in Eastern Europe in the 1950s, 1960s, 1970s just thought what we've got these emerging norms now. We've got these mechanisms. There's nothing we can do. But then the situation changed eventually, and we're able to, you know, keep gathering information, have mechanisms that could come into force. So I think one of the things is kind of international law is is always been there. It doesn't preclude kind of negotiation or compromise, but international law allows negotiated territorial adjustments and security arrangements, but it doesn't allow the permanent acquisition of land by force. It doesn't allow demographic engineering. It doesn't allow impunity for grave crimes. When we looked at the disintegration of the former Republic of Yugoslavia, then we're able to kind of say, well, we've got a political process whereby we can kind of come to new territorial arrangements and security arrangements. And we had like a political process that tried to bring that about. Um, but I don't think it's dead in the sense that you know, it's kind of it's worked in a number of places, but it hasn't worked consistently. If we look at Namibia, if we look at South Africa, if we look at Chagos, then we've had articulation of norms and we've had respect there. So I don't think it's a kind of all or nothing situation. There have been moments and times and places of success, and then there's been places of just utter kind of like darkness and brutality and raw power. But it's difficult to see how things might go in the future. Things do change. As I said, kind of in the 1970s, who would have thought that we would have had kind of extraordinary chambers for Cambodia with members of the Khmer Rouge being prosecuted in 1993? Who would have thought that we would have had, sitting head of state, Slobodan Milosevic, being prosecuted before an international tribunal? So sometimes things can seem very bleak, but then they can come crashing down very quickly. And if you don't have a domestic, regional, or international regime that's based on legitimacy, good governance, rule of law, democracy, pluralism, I feel it's just questionable how long it can survive. And if it comes crashing down, as I said, we have the norms and the mechanisms to be able to kind of regulate that and put it on a good kind of political and then legal path to resolution. But if we look back to South Africa, I mean, 1960s to the 1980s, I think very, very bleak, desperate times with the crime against humanity of apartheid. You had a form of like racial rule and domination there. You had civil society being repressed and persecuted through the law. You know, when you were amongst that, perhaps that's kind of where we are now. We're, in situations like Israel, Venezuela, United States. But I think the international community just kind of developed norms politically and then legally monitored it. And then various lines of operation, which is just, we're going to have sanctions against you. We're not going to allow companies to deal with you. And then just the speed with which transition occurred. Um, Maybe admittedly, a lot was achievable in the space after 1989, potentially. Maybe that's one way of looking at it. Potentially now we could be in a period of, 30 to 40 years of this kind of Cold War type of situation, potentially. But out of the last Cold War came a lot of transitional justice. Maybe we're in a new type of Cold War scenario now, perhaps. And I don't think we should kind of give up hope. At the end of this, we have the norms, the mechanisms, the skills for transitional justice. We have the ability to put back in place guardrails and think what's the most appropriate situation to do here. You think about occupation of Hungary, occupation of Czechoslovakia at the time, and that process of criminal accountability for senior leadership, but then the process of kind of removing these people from positions of power as well. I feel that America has been teaching the world a lot about this for 30 years or more, kind of transitional justice, lustration, how to kind of deal with this space after authoritarianism. And I feel these lessons now will come back to the United States, and seeing what I've seen from American journalists, American civil society actors, I feel that these lessons are very much in their heart, and they're going to be brought to bear against what seems to be um, a type of unitary executive, a type of autocratic legalism that's completely inconsistent not only with international law but against the United States Constitution. So America's a very young country, isn't it? And this might just be part and parcel of developing its kind of constitutional rules and putting into place guardrails. Just, in terms of international law failing, I just encourage kind of listeners to look at the Office for the High Commissioner for Human Rights, because it's got a dashboard that you can look at. It's this interactive dashboard where you can look at various states and look at the kind of human rights commitments throughout the world, like what human rights treaties has a state ratified. If a state has ratified a treaty, the individuals from that state then have the right to bring communications against that state before the UN human rights system. And I was looking at this the other day, and I just thought it's interesting just to see that Russia has ratified more international human rights conventions than the United States. But does that tell us everything? Does that tell us that kind of that the system is working or failing? Well, it doesn't give us a complete picture, because you might say Russia has ratified these conventions, but it's certainly not implementing them. United States, to a greater or lesser extent, has not ratified most international human rights conventions, but I think the argument is it's got its domestic constitution, it's got state and federal law that can protect human rights. And still, it's a young country, and this crisis hopefully will kind of strengthen its guardrails in the future. So that's just kind of me on the other side of the pond, really kind of expecting the worst but hoping for the best.